system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.
That requires you to do that. I'm going to ask that you pause before you answer the question so that the attorneys can take it up with the judge at the bench, all right?
Yes, ma'am.
All right. We talked last time you were on the stand. We're not going to repeat any of that, but you told us, well, let me put it a different way. At some point, did you receive information from federal inmates about a statement that Diego had made?
Yes, ma'am.
And did you investigate that?
I did.
And were additional inmates, including Diego's cellmate, interviewed about that statement?
Yes, ma'am.
And were any of the other inmates that you talked to, were any of them able to corroborate that statement?
No, ma'am.
And in the statement that Diego allegedly made to a federal inmate, did Diego confess to killing Laken Riley?
No, ma'am.
Did Diego say he killed Laken Riley?
No, ma'am.
Did you also know that the inmates at that particular federal facility are issued tablets?
Yes, ma'am.
And what's a tablet?
A tablet is a computer similar to an iPad or a Microsoft Surface.
And on those tablets, are the inmates able to access the internet?
Yes, ma'am.
And the particular indictment in this case, in the case of Laken Riley, does it mention the weapon that was used to kill Laken Riley in the actual indictment?
Yes, it does.
And how does it do that?
One of the counts dictates or states that Laken Riley was killed by the use of rocks.
Okay, and is that information widely out there in the public?
Yes, ma'am, it is.
I want to ask you about your interview with Diego Ibarra, and now we're going to talk specifics. What date did you interview Diego Ibarra?
Friday, February 23rd, 2024.
What time did your interview start, and what time did it end?
The interview started at approximately 5:13 p.m. It lasted for 91 minutes, and the interview was terminated at approximately 6:43 p.m.
Was your interview recorded?
It was audio and video recorded.
Who was in the interview room with you?
Special Agent Ashley Isaacson, also of the Georgia Bureau of Investigation, and Immigration and Customs Enforcement and Removal Operations Officer, otherwise known as ERO, Officer Wagner Machado. Officer Machado acted as a translator from Spanish to English and English to Spanish.
And in your interview with Diego Ibarra, and we're going to play just portions of it for the court, and the council's welcome to play whatever parts they'd like to play, but we clip this 91-minute interview to about 3 clips. And I want to talk to you about, we're going to play these 3 clips, but before I talk to you about them, do you recognize, or before we play them, do you recognize states 329?
Yes, ma'am, I do.
What is it?
That is a thumb drive that contains clips from my interview with Diego Ibarra.
And state move to 329 and request permission to publish.
No objection.
329 submitted.
In your interview with Diego Ibarra, did you ask him if he had anything to do with the murder of Laken Riley, basically?
I did.
And what was his response?
He said he had nothing to do with it.
And does he tell you where he was at the time that she was murdered? You ask him that.
Yes, I do.
And what is his response to you?
His response that he was sleeping in bed.
And were you ever, in all the hours that you spent, and let me just ask you this, how many hours have you spent investigating the murder of Laken Riley?
Hundreds.
And in the hundreds of hours that you have spent, what about your colleagues who are working this case with you at the University of Georgia Police Department and at the FBI, So Sergeant Norris, Sergeant Rabu, and Special Agent Hipkiss combined. How many hours have y'all worked?
It combined is thousands of man hours that have gone into this investigation.
And in the thousands of man hours that have gone into this case, have you been able to find any evidence that contradicts Diego Ibarra's statement that he was at home at the time?
I found no evidence to contradict the statement that he was at home at the time.
I'm gonna go ahead and play clip one for the record.
Wednesday, I started work at 4 in the afternoon. I'm supposed to have started at 3, but I didn't have a ride. I have a friend that sometimes gives me a ride. I didn't have a ride, so I got to work at.
And I need to stop you right there, clip one. Is that ERO Machado that's speaking?
Yes, that's correct.
And he starts with Wednesday. So what day of the week was February 22nd, 2024?
That was a Thursday.
Okay. So when he says Wednesday, he's talking about now the 21st.
Correct, he's talking of the previous day.
And if Laken Riley was killed on Thursday, then the following day when Diego Ibarra and all of the Ibarras are identified, that would be Friday?
Correct.
Thank you.
4 o'clock on Wednesday. Okay, so el miércoles usted entró a las 4 entonces. Sí.
And his work's still usually done at 11?
Y entonces el miércoles usted acabó el trabajo a las 11.
Trabajó 11 de la noche.
Yes, 11 at night.
Then after work, where did you go?
Y después del trabajo el miércoles, ¿dónde fuiste usted?
En la casa, porque nosotros no conocemos a más nadie aquí, no tenemos más ningún conocido. Nosotros somos nosotros y más ningún conocido así.
Okay. So we went straight home. I went straight home. We don't know anyone around here. We're just united together, and we don't know many people around here.
Okay, what time did you get home?
¿A qué hora llegaste a la casa el miércoles?
A las 11, porque ese es el horario de salud.
No, se salió a las 11. ¿A qué hora llegó a la casa?
A las que me echó media hora caminando, 11:30, casi a las 12.
So, he walked, so he said he got home 11:30, almost 12 o'clock.
Okay, when you got home, what did you do?
Cuando usted llegó a la casa, ¿qué hizo usted?
Llega, reposó un ratico y espera que el cuerpo se me enfriara para meterme a bañar.
So he got in and just rested for a little bit, and then took a shower.
Okay, who was home when you got home?
¿Quién estaba en la casa cuando usted llegó?
Estaban ellos, porque ellos saben más temprano, los hermanos míos. Ellos saben más temprano, ¿entiendes? Yo soy el último que salgo ahorita en este horario.
So it was them at the house. My brothers were there, because I'm the one that gets home the latest. They get home earlier than I do.
They were all there?
¿Todos sus hermanos estaban en la casa?
Sí, todos estaban allá en la casa ya.
And then what time did you go to sleep?
¿Qué hora que usted fue a dormir?
No, yo me pongo a ver el teléfono y no te puedo decir qué hora porque me pongo a ver el teléfono, a escribirle a mi familia, a mi hija.
Pero más o menos.
No, ni idea, porque tú sabes cuando uno se queda dormido, uno se queda dormido, uno no ve la hora, ¿entiendes?
Okay, so he said I want to be able to tell you the time, because when I get home, after I do what I do, I get on the phone, I'm playing on the phone, talking to my daughter, and just fall asleep. I can't tell you the time that I fell asleep, but I just fall asleep.
Okay, would it have been, he can't give you a range, was it a couple of hours after he got home, or had the sun come up?
Entonces, cuando usted fue a dormir, dame más o menos si fue algunos minutos, algunas horas, o ya salió el sol.
No, tampoco así.
Nada.
Como más o menos cobré más o menos me fue contando como a la 1 y pico, algo así, porque.
So if I had to guess, I would say probably 1 o'clock, one and some change.
Okay, and then what time did you wake up? Yesterday.
¿A qué hora que usted despertó ayer?
Ayer que miércoles.
No, ayer fue jueves.
Sí, ayer desperté que como casi me paré tarde porque me pararon, pero los hermanos míos me pararon que como a las 2 y pico.
A las 2 de la tarde.
Sí.
A las 2. ¿Su hermano? ¿Cuál hermano?
El men y la gorda.
Te despertaron.
Sí, porque ellos se estaban alistando para irse a trabajar y ellos me pararon, no, bueno, voy a ir a trabajar.
Okay.
Era tarde.
So yesterday, his sibling woke him up, Manny and the partner woke him up. He said it was around 2 o'clock. talking about.
So you were asleep from about 1 o'clock in the morning until 2 o'clock in the afternoon?
Entonces usted estaba dormido más o menos de la 1 de la mañana hasta casi las 2 de la tarde el mismo.
Does that complete the first clip?
Yes, ma'am, it does.
I'm gonna play published clip 2 from June 29th.
So we're about to show you a video, and we want you to tell us who you think the person in the video is, or if you know who it is.
Vamos ahorita en este momento.
Because it's difficult for us to see what video is he shown at this time?
Special Agent Isaacson shows Diego Ibarra the video of Jose Ibarra disposing of a jacket in a dumpster.
Entonces enseñarle un video y queremos saber si usted conoce quién está en este video.
Is that okay?
Yes.
Okay. Do you know where this is?
¿Sabe dónde es eso?
Ya.
Yes.
Who is this?
¿Quién es eso?
Ese es mi hermano, veníamos, nosotros estábamos los juntos ese día.
That's me and my brother. We were both together that day.
Okay, there's only one person in the video, so who is that?
En el video solamente tiene una persona. ¿Quién es?
Is that you or your brother?
Sí,
¿Es usted o es su hermano?
no es de él.
It's him.
Him?
No, it's his brother. Sorry, about him. His brother.
Okay, I'm gonna rewind it and let him watch it again.
Usted va a ver otra vez.
And where is this?
¿Dónde es eso?
Esa es la basura donde nosotros vivimos.
This is in the trash can or the back over there by where we live.
Okay.
No, ese está pegado, no está.
He said rewind.
Yes, I did. Just give it a second.
Dame un segundo.
You'll still see him walk. Is that his hat?
Esta ahora es su gorro.
Sí, es mi gorro.
Yes, it's my hat.
Okay, does he know what his brother is doing?
¿Sabe qué está haciendo su hermano?
Yo me estaba botando la basura. Creo, yo sé, ahí te estaba botando la basura.
Looks like he's throwing something in the trash.
Okay. And how does he know this is Victor?
¿Y cómo que usted sabe que es su hermano? Víctor.
Porque ahí esa ropa yo se la vi a él.
Because that seen in that clothes.
Claro.
Okay. Are these clothes that only Victor wears?
Esa es la ropa que usa Víctor. Nada más.
Esa ropa que en vez estaba para su trabajo y todo.
And that's the clothes that he wears to his work and everything.
Okay. And I'm gonna show him one more picture. Or yeah, he's gonna show him one more video
I
to
got
see.
one more video for you to look at.
Otro video para ustedes mirar.
I'm gonna let you watch it, then I'll ask some questions.
Usted va a ver el video, después va a hacer algunas preguntas.
Based on that,
Esos videos de atrás de agarramos el tubo.
What video now are you showing at this point at 6:19?
I'm showing Diego Ibarra the video of Jose Ibarra at the bus stop near or at Rogers Road near Building S.
So this is a different video than the one you just showed him.
It is.
The videos in the back where we take the bus.
that's at the bus stop.
Es en la parada del autobús? Yes.
Can you tell who that person is?
¿Quién es esa persona?
Ese es el hermano mío.
That's my brother.
Claro.
Is it
Of
Victor?
course.
Sí, ya lo van a reconocer yo mi hermano.
He said, of course, that's my brother Victor. I know I recognize my brother Victor.
How does he know?
¿Cómo que sabe?
Porque esa ropa es la misma, esa chaqueta es la que tiene en la casa.
Because that's the jacket. That's the
Sí,
jacket he
esa
has at home.
claro. Ahí sabe yo como mi hermano.
And he
I
has,
know
he
that's
has,
my brother.
he has a little bit of a mustache too.
Does he know why he has gloves on?
¿Usted sabe por qué está con guantes?
Yo también uso guantes, yo en el bolso mío también
Eso
tengo.
es la pregunta. ¿Sabe por qué está con guantes?
No sé por qué está con guantes el frío, me imagino yo.
I don't know why he's with gloves, the cold, I imagine that.
Does he sometimes bring gloves home from work, from the Chinese restaurant?
Cuando está allá trabajando en el restaurante de él, él viene para casa con guantes, ¿sí o no?
Sí.
Yes.
Describe the gloves that he usually brings home.
Describe las guantes que trae para
Son los mismos que yo tengo metido en mi mochila, son esos.
It's the same ones that I put in my backpack, the same ones, yeah.
This backpack that you can see Victor carrying, is that his bag or is that yours?
Esta mochila ahí que está con Víctor ahí es la mochila de Víctor o es suya.
No, esa es la de él, esa no es la mochila mía es la de atrás.
Is that your gray backpack or is that his?
Esta mochila gris es tuya o de
Esa es su mochila. Yo la mía es así, pero yo la mía es de espalda.
He said, okay, mine is a backpack. I don't know what he's looking at there. He said that one not, but his is gray as well.
That's a bag that kind of goes across your body?
Chino de lado.
La mochila que usted trae
De espalda.
de espalda y de Víctor es que
De lado.
de lado. Victor wears the backpack that goes across the body.
Has he seen Victor with that bag before?
Usted ha visto a Victor con esta mochila antes.
Sí, claro, la tiene en la casa.
Yes, of course, he has it at home.
How often does he carry it?
Tiene sus cosas ahí metidas.
¿Qué tan pronto él trae esta mochila con él?
No, tiene tiempísimo con su mochila.
Él lleva la mochila cuántas veces por día, por semana.
Ahí tiene todo sus cosas, su cédula, todo su vaina, ¿entiendes? Su colonia, tiene todo ahí metido.
Entonces él trae la mochila todos los días.
Claro.
Okay, so he's with the bag every day. He carries all his personal items in that bag.
Is that bag in the apartment right now?
Esta mochila está en los apartamentos.
Está en la casa.
Yes, it's at home.
Where?
¿Dónde?
En el apartamento donde vivimos nosotros.
In the apartment where we live.
Where is that?
Does Victor have a bedroom where he keeps that bag in?
Él tiene un cuarto donde él deja
Vivimos
esta
todos,
mochila.
un solo cuarto nada más vivimos todos.
We all stay in one room. We all stay in one room.
Claro,
One room
claro.
that we stay together.
Dos camas, una donde duerme la gorda y el otro me mío, Giancarlo en un mueble y yo viví todo junto.
¿Cuántas camas entonces?
Dos camas y un mueble.
Okay, so he's saying two beds, and I think he's saying what's it called? Futon? El mueble.
Mueble.
Sí, con un sofá que se abre,
Sí.
con cama.
Yeah.
Okay, so he's saying like a futon and two beds.
So if we walk in the front door, like guide us to where Victor's belongings would be.
Entonces, entrando por la puerta de la frente, guíanos para donde, vámonos para la izquierda o derecha, para cómo entramos, guíanos para llegar a esta mochila.
La mochila en mano, ahí pueden entrar en la puerta y todas las cosas, nosotros no tenemos nada escondido porque no somos delincuentes, como le digo, ¿entiendes?
Sí.
Todo está en su sitio, no somos delincuentes para estar escondiendo nada, ¿entiendes?
No, pero la mochila va a estar donde, ahí se
Ahí
quita de la
está,
puerta.
sí, ahí tiene que estar montada arriba, donde duerme, donde dormir, si no está en la cama, tiene que estar ahí donde está toda mi ropa, donde está toda mi pertenencia, ahí tiene que estar.
Entonces, explícame, entrando por la puerta, ¿dónde va a estar esta mochila?
Si no está en la cama, tiene que estar en la pertenencia donde yo tengo mi ropa doblada.
No suya, de Víctor.
Que todos somos hermanos, todo está junto.
Okay. So he said, coming in, if it's not right there on top of the bed, it's gonna be by their stuff where they keep their clothes next to the bed somewhere.
Is that on the left or
¿Es
the
el
right?
lado izquierdo o derecho?
De izquierdo.
Left side.
And finally, clip 3.
Would you be surprised that much of the evidence that we collected during our investigation points to Victor as the person that hurt the student?
Va a quedar usted sorprendido si la evidencia que nosotros agarramos está indicando que Víctor lastimó a esta persona.
Tienen que tener evidencia, como que digo.
Eso no es que le pregunté. Va a estar sorprendido, sí o no.
Si usted dice que estoy
¿Sí o-
acá,
va a estar sorprendido, sí o no.
yo no puedo decir que sí porque no sé, yo no puedo decir que sí.
Sí, yo voy a decir ahorita que su hermano Víctor
Ah,
le lastimó la persona que estamos investigando.
quedaré sorprendido, quedaré sorprendido, quedaré
Of course, I'm going to
sorprendido.
be surprised. Of course, I'm going to be
Claro,
surprised.
porque tienen que tener evidencia, me
We're
imagino
going to
yo.
have to have evidence.
Yes, we understand.
Entendemos eso.
But again, he doesn't know, you don't know anything about that, correct?
Pero otra vez, usted no sabe nada de eso.
No sé nada de lo que está pasando ni nada, me quedo sorprendido porque me están investigando a mí también, me quedo
Hey,
sorprendido.
I'm surprised. I'm surprised because you're investigating me as well. I'm
Yeah.
surprised.
So-
At no time in the past 12 to 24 hours did Victor tell you any information about hurting somebody.
Entonces, en ninguna vez, ahorita de las 12 a 24 horas, has dicho, Víctor, que algo olvidó, que pasó algo.
¿Te pasó algo?
Sí,
No.
no.
At any point in time, did you participate in trying to cover up somebody being hurt?
En cualquier tiempo, participó usted en alguien estando lastimado.
No participó en nada malo que no me involucre en nada, ¿entiendes?
Dígame otra vez.
Que no participaba en nada, nada.
I didn't participate in anything.
That completes the clips of that interview that the state wishes the fact finder to consider, and of course, the other side can play what they wish, and at this time, I'll pass it.
Good morning, Agent Byer.
Morning, ma'am.
You interviewed Stephanie Slayton for this case.
That's correct.
In your interview with Ms. Slayton, she was cooperative.
Yes, she was.
She volunteered to let you download her phone.
She volunteered to allow us to download her phone. We did not do it.
And she expressed fear of speaking to you.
Yes.
She specifically was afraid of retaliation for her statements.
Yes,
Retaliation from Diego.
that's correct.
When you confronted Diego about whether or not he had threatened Ms. Slayton, he denied doing it.
Correct.
When you were speaking to the state, you said that you had no evidence to contradict Diego being at home on the morning of February 22nd.
I have no evidence to contradict that he was anywhere other than at home. He did not appear on any video in the apartment complex. He did not appear on the trailer camera.
Multiple people reviewed that video of someone throwing away a jacket in the dumpster.
Yes,
Multiple people identified that person as Diego.
the only person that I'm aware of that identified it as Diego was Stephanie Slayton.
Bethany Paisley also said
Objection, hearsay,
it's rebutting, it's impeaching
call a
him.
witness.
No, it's. Bethany Paisley also said that the person in the dumpster video looked like Diego.
Looked like Diego, but to the best of my knowledge, she was not confident in that identification.
No further questions.
Bethany Paisley couldn't tell you who it was in the video, is that right?
Correct.
And the people that could tell you were Roast Belly, correct?
Yes, ma'am.
Who came from New York with Jose Ibarra, right?
Correct.
And lived with Jose Ibarra for months.
Correct.
Is the same race as Jose Ibarra.
Correct.
Speaks the same language as Jose Ibarra.
Yes, ma'am.
She was able to identify him from the video.
She was.
Was she in any doubt in her mind that that was Jose Ibarra? Did she ever express doubt to you?
No, ma'am.
Same question about Diego Ibarra. Diego Ibarra is Jose's brother.
Yes, ma'am.
Diego Ibarra identified his brother in that video.
Yes, ma'am.
Did Diego Ibarra express any hesitation, any doubt that he was looking at his own brother?
No, ma'am. He said, of course I know my own brother.
And he did it in both videos, correct?
Yes, ma'am.
Stephanie Slayton, how long had she known Diego?
Maybe a little bit over 6 months.
Same question about Jose Ibarra. How long had she known him?
A similar period of time.
And she's the only person who expressed an opinion different than that of Jose Ibarra's brother, correct?
That I'm aware of, yes, ma'am.
And the only person that expressed an opinion different than that of Rosebelly, Jose Ibarra's roommate.
That I'm aware of, yes, ma'am.
And in your investigation, Special Agent Beyer, is Diego's DNA underneath Laken Riley's fingernails?
No, ma'am.
Is Diego's DNA on the blue jacket that was found in the dumpster?
Your
No,
Honor,
ma'am.
I would object. This is a closing argument. She's making, this witness didn't have the DNA.
Is Diego's thumbprint on Laken Riley's phone?
No, ma'am.
That's all I have, Your Honor.
Anything else, Ms. Beck?
No, Your Honor.
Can you be excused?
Yes, sir.
No objection.
Thank you, Judge.
Anything else from the state?
No, sir. The state rests for battle.
Anything from the defense? Can I just look at these last exhibits real quick? While you're doing that, I'm gonna review the exhibits, or is that what you wanted to look at?
Yeah,
What they were, but I just wanna. Give me a moment to look at these exhibits.
Yes, sir.
an announcement by the state and the defense. The evidence is closed.
Yes, Your Honor.
Are you all ready to go into summation?
State is ready, Your Honor.
That's ready, Your Honor.
Okay. Ms. Ross, you have opening and concluding.
Yes, sir. May it please the court and counsel. Your Honor, Laken Riley herself has given you all the evidence you need alone to find this man guilty of every single count in this indictment. And as I said in my opening, and what the evidence has shown in this case, is that she did fight. And it is a direct result of that fight that gives you all the physical evidence you need to convict him. And if you only had that physical evidence, you would have enough to convict him. But what you have heard in the last few days in this trial is video evidence laid on top of the physical evidence that corroborates it. Digital evidence laid on top of the physical evidence and the video evidence that all corroborate one another. And the three forms of that evidence in this case, the physical evidence, the video evidence, and the digital evidence, combined twist this very powerful knot that this defendant cannot get out of. There is no way out for him. The evidence in this case has been overwhelming. And the evidence in this case has spoken loud and clear that he is Laken Riley's killer, and that he killed her because she would not let him rape her. And look no further, you have to look no further to his actions 73 minutes before he encountered her on the trail to know what he was up to that day. And so not only does the physical evidence identify him, the video evidence identifies him. His own brother identifies him. His roommate, Rosebelly, identifies him. The people who he was living with condemn him. But his digital evidence of posting selfies of himself wearing what is basically his rapist gear an hour before he leaves his house, that condemns him. He has condemned himself. And what I'm going to do in the time that I have before this court is review the evidence that this court has heard and ask that you find him guilty on every single count of this indictment, not because you feel sorry for anyone, but because he earned it, because he deserves it, and because we have proven it beyond a reasonable doubt. Let's start with the physical evidence. The defendant's DNA is under the right fingernails of Laken Riley. And it is only Laken and this defendant in that sample, and no one else. It was first done at True Allele, and because our Hennis and this defendant are blood brothers, he couldn't be excluded under YSTR. And then it was Diego who could be excluded by YSTR because he has a genetic mutation. But True Allele, when looked further in at the sample, eliminated both Diego and our Hennis. So the evidence in this case has been, and is, that it is only the defendant and Laken Riley underneath her right nails. And how did that happen? Because she, in her fight, marked him, scratched him. And the testimony from Ms. Hinkle yesterday, when asked, well, how do you get a person's DNA underneath your fingernails? One of the first things she says is scratches or bodily fluid. Casual contact is not enough, and wearing an item is not enough. And how do we know that? The black Adidas hat that we all see for our own eyes on Diego's head doesn't have his DNA on it. I mean, contact DNA isn't the magic bullet that everybody likes to pretend it is in front of a jury. But we know Diego was wearing that hat. You can see it for your own eyes. And I'm going to talk a lot more about that hat and why and how Diego was wearing that hat a little later. It is the defendant's thumbprint on Laken's phone. And this was from the Daubert hearing. This is, first of all, the digital image of Special Agent Daniela Stewart. And that is digital image 597, which is in evidence on one of the thumb drives. And the court heard the testimony that we adopted from the Daubert hearing, and I have here states 28 from the Daubert hearing of October 11th, where where Sergeant Stewart of the ACC Police Department, who has been a latent print examiner since 1994, has looked at thousands of prints, compared that image that Special Agent Stewart took on the night of Laken Riley's murder when they finally found her phone after dark away from her body, and he compared it to the known fingerprints of Jose Ibarra, and he did it twice. And he found and explained to the court at the Daubert hearing, which we have adopted as part of this transcript, 15 points of comparison and similarities between the latent print left on Laken Riley's phone and Jose Ibarra's fingerprints. So in order to find this defendant not guilty of killing Laken Riley, you would have to disbelieve DNA. You would have to disbelieve fingerprint evidence. And even if you did that, you would still have this. Quite frankly, she got him. She scratched him. And you heard the testimony from Sergeant Epps and from Corporal Sayan. The left wrist was still oozing. Both of them saw that. And when asked, what's with these injuries by Corporal Sayan, and we played that part of the body cam video for the court to see, Corporal Sayan wasn't coming at him hot. It was super calm and casual. They're out there laughing. They're laughing in those videos. Smoking, talking on their phones, talking to one another, all four of those people inside that residence, chillaxing. And Sayan's like, my friend, do me a favor, show me your hands. My friend, how did you get those injuries? And his first response is that of a monstrously guilty individual. What scratches? Y'all don't see these scratches. We don't see these scratches. So in order to find him not guilty, you would have to disbelieve your own eyes. What scratches, he says? All of those scratches. And there were more scratches than that, because when Daniela Stewart, and those photos are in evidence to you, when she photographed him and made him take his shirt off, there are scratches on his back. His back. And you know what that's consistent with? That is consistent with him asphyxiating her, being on top of her, compressing her chest, and smashing her head in with that rock. That's what that's consistent with. How do you get scratches on the back of your neck? How do you get scratches on your back? Laken left those scratches, and the physical evidence says that she left those scratches, because that is why his DNA is underneath her right fingernails. She marked him. She marked him for everyone to see. She marked him for you to see. And the digital evidence that she wore that day also corroborates everything, all the physical evidence and the video evidence. We will never know. We will never know what he did to her on that trail and in what order. And we'll never know what he did to make her stop. Because quite frankly, I am certain she could outrun him if she wanted to. But she didn't. And he did something to her where she knew immediately she was in trouble. And how do we know that? From the Garmin and her phone. Simultaneously, if you put those two things together, which is what this graph is that you saw and that's in evidence, at 9:10 a.m., and there's some seconds in between them that really only matter if you're an Olympian swimmer or a track runner. It's so close together in time, it doesn't matter. It is simultaneous. Simultaneously, she enacts or tries to call 911 from her phone using the SOS function of her iPhone. And we know that from her phone. And simultaneously, at that same time, she comes to a dead stop. She stops in her tracks. And we know that that is the time she meets him on the trail. And how do we know that? Well, we know that from the FBI. Because there is a chart that I'll show you a little later in my closing argument, where at 9:10 a.m., their digital profiles overlap one another. They have met in that woods. His from his timing advanced data from his phone. And remember, the moment he enters the forest, his Wi-Fi is no longer active. And so there's no Reuben data from about 8:55 to about 9:40 a.m. And that is evidence of his guilt too. The fact that he's in that forest, that means he's in the forest. And we know he's in the forest because he has no Reuben data. And we know he's in the forest because his timing advanced data puts him there. And they meet simultaneously, digitally, on that trail at about 9:10 a.m. And so something happened, and this is her Garmin watch. And we know there was a fight because the way that it looks, look at this, on the trail, she's still on the trail till about 9:14 a.m. And then her Garmin starts moving off the trail. And he takes her off that trail 65 feet, 64 feet and 11 inches to be exact, 65, close enough. And he does that for only one purpose, and that is to isolate her so that he can victimize her. And that is exactly what he did. But the true allele under her nails, as damning as it is, isn't all that you have. And you could put that aside and the fingerprint aside, although there's no reason to. On the jacket that he is seen throwing away about 12 minutes or 14 minutes after her heart stops beating. And it is no coincidence that he is in that forest until her heart stops beating at 9:28 a.m. And it isn't until around 9:40 that he emerges. He is with her that entire time. But about 14 minutes afterwards, he is seen on video dumping a jacket that you have here in evidence that you've seen a lot, so I'm not going to show it to you again, that has a mixture, and this is traditional DNA. This is not true allele. This is not probabilistic genotyping. This is traditional DNA, and it is a mixture between only two people, Laken Riley and this defendant. And it's no mistake that it is blood, a mixture of their blood on that jacket. And on that jacket also are 29 hairs that are consistent with Laken Riley that all have been not all of them, but several of them have been forcibly removed from her head. And they were wrapped around the button that you see in some of the photographs when Officer Davis testified, the way that he saw it. And it is a rare day that as a prosecutor, we ever get such great evidence of tampering with evidence. But the defendant himself is on video, and here it is. And now I guess the defense will have you believe he just threw away that jacket right at this moment just because he just didn't want it anymore. That's not reasonable. He threw away that jacket because he knew exactly what was on it. He knew it was his blood, he knew it was her blood, and he knew he had to get rid of it. And he also knew that he had to get rid of his gloves, and so what he does further on in this frame is you can see him take them out of his pocket and throw it in the bushes. And on those gloves is Laken Riley's blood. He threw away the gloves because he knew what he had done. He knew her DNA or her blood would be on that, and he got rid of it. That is what we call consciousness of guilt in our business. He threw away those items because he knew he had killed her, and he threw them away because he didn't want anyone to find him. That's why he did it. And what's so fascinating about this video is the part where he looks at the hat. Let's talk about that. Guess what he didn't throw away? The hat. It's his brother's hat. Diego said it in the interview. That's my hat. He wears his own brother's hat to go kill someone. And he looks at it. Oh, no blood on that. He didn't see any blood on it, although there is her blood on it. Puts it back on his head. Doesn't throw that away. And then lets his own brother walk around with it the next day. And the fact is, if Diego had not been wearing that hat, we may have never caught these people. We may have never caught him. But Diego was wearing that hat. Do you think for 1 minute, Diego would have to be the dumbest killer on the face of the planet if he killed Laken Riley and was still wearing that hat around? Because what Laken Riley's killer did was he got rid of all the evidence. At least he thought he did. And that hat right there, he couldn't see her blood. And he gives it back to his brother. And luckily for all of us, his brother decides to wear that hat that next day. And we know his brother wasn't wearing the hat on that day because you got to see the video for yourself where Diego goes to work on the day of Laken Riley's killing. He's at work and he's wearing a completely different hat. And each day that we have of the videos of where he's going to work, he's wearing a completely different hat. So this defendant, this killer, gives a hat back to his own brother that he was wearing when he killed Laken Riley. And I have to take a moment. You know, the officers in this case have done a lot of things. They dived into dumpsters. Daniela Stewart told you she was on her hands and knees on that crime scene looking for rocks that were similar. Couldn't find any rocks around where Laken Riley was murdered. A lot of it, you know, Sergeant Timothy Johnson, whose testimony we adopted from the hearing in October, you know, just hitting the streets looking for things. Zach Davis, dumpster diving. It was a combination of good police work and, quite frankly, just luck. We were lucky that Diego decided to wear that hat. And do you think for 1 minute if Diego had killed her, he would have put that hat on? No. And looking in the video that you see, and you saw slowed down versions of it, Diego has tattoos on the back of his neck. They are not in that video. Rosebelly herself, who knows both of these two, identified this defendant in that video. And if you're concerned about whether she's right about that, well, the FBI's digital profile of this defendant's device hovers over that dumpster at 9:40 a.m. It's him, and there is no doubt that it's him. Here is the FBI profile, digital profile from the CAS team of the defendant's device now over the dumpster. In the center of this is D1, 9:40 a.m. He's at the dumpster that we just saw him at, dumping bloody clothes. And how do we also know he's back at his apartment at that time? Because Special Agent Hipkiss, who extracted 1B7, said at 9:58 a.m. the device is plugged back in and charging, which means he's back home. But he's not done. And before I go on to the other videos, these are all the selfies of this defendant on his phone 1B7. And I understand, and I suspect maybe the defense will argue, well, Judge, you know, other people used his phone. Yeah, they did in October. And the other months that they want to talk about are other two accounts. Oh yes, Diego has a Google account that has been accessed from 1B7. Both of those accounts that they talked about, one a Facebook, one a Google, I can't remember exactly, but there were two of them. Rosebelly had one and Diego had one. One of the accounts was closed in January, and the other one, Rosebelly, was closed in February of February 12th of that year. So on the day in question, on February 22nd of 2024, there is zero evidence, no evidence that anyone other than this defendant was using that phone. And any attempt to argue that someone else was is just pure speculation, because the only activity on the phone prior to leaving is him taking that selfie at 5:30 in the morning. That's it. There's no one texting, no one WhatsApping, no one calling in the time that he's out hunting and killing, because he's holding the phone and he's a little busy because he's looking for victims. He's looking for females. Nobody else is using that phone. And the FBI said, and the phone tracks his own video. You could put the video of him at the bus stop, which I'll show, and put it with the digital profile of the phone, and they track one another. So the videos and the digital profiles track one another because he's holding the phone at the time. And this is what he does when he gets back. His phone is plugged in at 9:58 a.m., but he's not done destroying evidence. That shirt that he's seen wearing with the black and white pattern in the video, in the dumpster video, a few minutes later when he comes out of his house at 10:21, he's changed. And now he's wearing the clothes that he's actually arrested in. This is him 10:21 a.m., and he's got a bag in his hand. I really wonder what's in that bag. Never found that bag. And he didn't want anyone to find that bag. And how do we know that? Because he's walking towards a dumpster. And Sergeant Norris said that that dumpster in that part of the apartment complex had been picked up about 45 minutes later that day. So they weren't able to get and see what was in that bag. And no one ever found what was in that bag. But you know what was also never found? The striped bag that he's wearing over his, that sling bag that he's wearing in both the dumpster video and in the bus stop video. That bag was never found, ever. And I suspect it's because it was in that bag that we just see. And here he is coming back 3 minutes later, and there is nothing in his hand. He's gotten rid of the rest of the evidence, because that's what guilty people do. So the digital evidence that I have talked about, in summary, from Special Agent Jay Burney of the CAS team, it is his opinion that he left that house at 6:52 a.m. and that he returned around 9:50 a.m. And that there is no Reuben data on that phone from 8:55 to 9:40, which is consistent with him being in the forest. This is the slide from, and this is what summarized Special Agent Burney's testimony, that at the time at 9:10 a.m., so on this slide here that was before the court, page 29 of his exhibit, at 9:09 a.m. to 9:12 a.m. is where on the trail Laken Riley and this defendant meet digitally and in person. And so that is pretty much the evidence. His DNA is there, his thumbprint is there, and he's on video dumping evidence associated with the crime shortly thereafter. I want to talk to you about the charges in the case, and this is usually when I would go on much longer with a jury, but I don't think there's a need to do that with this court. These are slides that I use in murder cases where I close all the time in front of juries. The court is aware that in the state of Georgia we have malice murder. The defendant is charged in count 1 of this indictment with malice murder. Malice can be proven in 2 ways, as you know, but we really don't even need to talk about implied malice in this case. This is express malice. Everything this defendant did to Laken Riley on that trail showed his intent to murder her. And what express malice is simply the intent to kill. And so what evidence is there that when he interacted with her on that trail and when he drug her off that trail that he intended to kill her? Well, look no further than the evidence of the medical examiner in this case. He put huge holes in her head with a rock. And he did it more than once. And there could be no other reason to do that other than to silence her forever, so that she could not call Sergeant Maxwell or anyone from the University of Georgia Police Department and report that he tried to rape her. Because guess who did call the police on him? Tejaswi. And we're going to talk about that county indictment. And he ran away after she confronted him at the door. So he had a motive to kill Laken Riley, but you don't even have to go that far. All you have to do is look at his actions and look at the state's exhibits that we admitted through the medical examiner and look at those 9 holes in the left side of Laken Riley's head. That's intent to kill. And the rock sure is a deadly weapon, especially when used that way. He used a rock like it was a hammer. And that's what he did to her. That's intent to kill. The petechia, also, because these are concurrent causes of death. Asphyxia. He asphyxiated her in some manner. Again, we'll never know everything he did, how he did it. But he asphyxiated her, we know enough. That caused petechia in both of her eyes and even at her lips. That is a tremendous amount of petechia that she has there from a compression or a strangulation injury. He was depriving her body of oxygen long enough to form those wounds on her. He intended to kill her. There is no other reasonable explanation for that conduct. We have also charged 3 counts of felony murder in this indictment. I'm not even going to define it for the court because I know you know what it means, so I'm just going to go straight to the felonies. And they are kidnapping with bodily injury, aggravated assault with intent to rape, and aggravated battery. First, with the kidnapping with bodily injury, that is exactly what happened in this case. And that actual felony precedes the murder in time, because he didn't murder her on the trail. He took her 64 feet and 11 inches off the trail for the purpose of victimizing her. That is asphyxiation, that is recognized under our law, and it is what permitted him to do the things to her that he wanted to do all along. And if he hadn't had asphyxiated her off that trail, he would have been interrupted. So it is a kidnapping with bodily injury. And I have a crime scene photo here from, again, Daniela Stewart, where she shows marker 1, which is Laken Riley's other AirPod. And that's how we also know there was a struggle on the trail. Sophia and Lily find, and we know Laken was listening to music when she was running. They find her AirPod, one of them, in the middle of the trail. And there's a photograph in there. A little towards the side, but still on the trail. AirPod number 2 is found by Daniela Stewart, where marker 1 is off the trail. So there was some kind of struggle between the two of them on that trail, and it's also shown on her Garmin, where she loses her AirPods on the trail. And he takes her off that trail. And we'll never know exactly how he took her off the trail. Did he pick her up and carry her? Did he somewhat drag her off the trail? Did he somewhat push her off the trail? We know that he took her 65 feet because we know that's where her body was found. And also Daniela Stewart saw like a leaf. She called it a displacement of the leaves, and she marked it with those orange flags, but no real dragging marks. So that's a kidnapping with bodily injury. Taking her off that trail, and in the commission of that crime, he kills her. He is guilty of felony murder, with the underlying felony being kidnapping with bodily injury. It's not contested that she has bodily injury. But the aggravated assault with intent to rape, there are a lot of questions about, well, you know, could her shirt be up from dragging her? I suppose the defense might be, well, I killed her, but I didn't intend to rape her. Well, that makes no sense. Because the only thing that makes sense about why these two individuals who don't know each other, never met each other, had this encounter on this trail at this moment while Laken is out for her morning jog, is because he wanted to sexually assault her. What evidence do we have of that? What has been left behind from the struggle that we can discern that? What circumstantial evidence? Well, her clothes are in 2 different directions. And it is important to talk about her clothes. And we're not talking about her clothes in order to shame her as a female. No. It's evidence on how she wears her clothes. She would wear running tights when she ran because that's what's comfortable. And that's how you run. And she would wear them over her navel because when you're running, you want your clothes to stay put. And she wore a Lululemon jacket, and she wore 3 layers of clothes that day. And it's important to talk about that from an evidentiary perspective because these are tight running clothes that are designed not to move. Not to move. And if they want to say dragging may have caused one of the layer of clothes to come up, all right, I'll give you 1. But I can't give you 3, and I can't give you the clothes going in 2 different directions. Her shirt was up. Her running bra up. Her jacket up, and her breasts were exposed. In a way that you saw in Sergeant Maxwell's body cam video, and in a way that Special Agent Beyer testified to the court, and he photographed them. They were twisted all together in a knot almost, above, and like almost tying down or pinning down her shoulders. That is not an accident, and that is not from dragging. And if you even want to think that that was from dragging, then how do you explain how her tights are down below her navel, which she never wore them that way? Her underwear is pulled up, and you can see it in the body cam video, and you can see it in the photos from Special Agent Beyer, and her underwear has been torn. He did that to her. He did that to her after he drug her off the trail. And he did that to her because he wanted to try to rape her. And we don't have to prove a completed rape, and thankfully she wasn't raped. But he tried to do it, and he was unable to complete it for some reason that we will never know. Maybe he didn't like the fight. Maybe somebody ran by. Who knows? But he didn't complete it, and we don't have to prove that he completed it. Injury to Laken's pubic bone, State's Exhibit 316, that also corroborates that he attempted to rape her. Why is that injury so low? All these injuries to her stomach, these linear injuries. That means her shirt was up when he's on top of her. Could it have been the bag? Possibly. It's consistent with a metal object. Never found the bag, don't know. But there's no reason for her to be exposed that way unless he was trying to sexually assault her. That is the evidence of aggravated assault with intent to rape. It's the only thing that makes sense about the encounter, but there's all that physical evidence that supports and corroborates that that's exactly what he did out there. Aggravated battery. I could talk forever about aggravated battery and disfiguring her skull. Just look at State's Exhibits 305 and 307. I really don't need to say anything else. Look at those two exhibits. That is the very definition of aggravated battery under Georgia law. He is guilty of aggravated battery and felony murder, with the underlying felony being aggravated battery. Obstruction of a 911 call. The SOS call was made, no doubt about that. We got that from not only Laken's phone, but we also got that from Kevin McCreevy from the 911 call center. She made a call. She made a call, it was answered. You heard the call. Kevin McCreevy testified. The caller hung up on the 911 center. That was his testimony. The 911 center called Laken back twice, and that you could see that in her phone. And neither call was answered. Who hung up the phone? Well, he did. How do we know that? State's Exhibit 28. It is no coincidence that his thumbprint is on her phone where you would go to hang up an iPhone. And also on that call, that is about a minute call, you hear him say, "Yo, Tango." I have. Yeah, you do. You do have. You had her phone, and he hung it up. And when 911 called back twice, no one answered. And her phone is separated from her body. So her body is in, she was murdered by the tree. She was moved and hidden and put leaves over her. And it worked because it took Sergeant Maxwell 20 minutes to find her, and he had her digital profile. And we didn't play the whole thing, but he testified it took him 20 minutes. And because he hid her, because he didn't want anyone to find her. We were lucky there too. But he separated her from her phone. Her phone was so far away from her, it took them hours to find it. You heard Sergeant Norris, I was walking through shining a flashlight. I almost stepped on it. You saw the video of his body cam. You saw how dark it was out there when they found his phone, her phone. He separated her from her phone because he didn't want her to complete that 911 call. And she didn't. He's guilty of that. Tampering with evidence. I've already covered this. It is rare we get this on video, but we got it on video. He's throwing away the bloody jacket. He's throwing away the bloody gloves. That's how it is alleged in the indictment. He's guilty of that. And I've already covered this. There he is, no tattoos, been identified, looking at the hat that he decides to keep. Here he is on social media, if you have any doubt that that's him, wearing the hoodie and the black Adidas hat. Did you a huge favor there as the fact finder. It's 5:37 a.m. on the day of the murder. He's about to go out, and that's how he's dressed. He is alone in all of these times. Trail cam video, Tejaswi and Sally, the other female runner that encountered him at 8:24 a.m. where he is what? In the woods. And how do we know that? Because when Tejaswi calls the police on him at about 8 o'clock in the morning, he vanishes and disappears into the back, and Sergeant Rabu testified in the direction of the IM fields. And he stays there. What's he doing there? What's he doing there? Well, he isn't running. I doubt he's bird watching. He's sitting there waiting for someone to come by because his first intended target, he wasn't able to get. And I'm going to ask if there are any cameras up. I want to show a portion of something that I don't want the peeping victim to be seen, the Tejaswi.
So I will direct media to not publish this as well as.
All right. So are we good? We're good. Okay. I'll let you know when it can come back up.
Hey, I'm sorry. Hey, can I come in or you? Alrighty. So I'm just gonna get one thing over the radio. 6427, I believe it's gonna be the north facing at the end of the building. Hey, so you okay? I'm okay. I gotcha. I understand it might be a little bit scary. I'm just gonna be asking a couple questions, get some clarifying information, okay? So you were taking a shower, correct? And you heard something going on?
Yeah, I heard like something was moving, and I just heard it was someone from upstairs. I usually hear that. And then when I actually came out, I heard it coming from the door.
Okay, you heard it coming from this door?
Yes.
Okay.
So I went to see to the people, and then I saw actually someone was like crouched down and then trying to I think I just open it.
Okay.
And then I thought it was just maintenance. I thought of opening, but then I was like, why would they do that right when you're first up?
Yeah.
So, and then I said, excuse me, and as soon as I said that, they tried to duck down, and I could see them ducking.
Mm-hmm.
And then they went away, and then after that I tried to get the phone. Then when I was standing by the door, then I could see them peeking, trying to peep and take a look.
They're trying to look into that. So at no point did they ever enter your
No, they
door. Okay, good.
In this frame, you can see, as some people would say, clear as a country mile to the back of Building S from Tasia Sweet's apartment. She absolutely saw him looking in her apartment. And when she said he was ducking, you can see that for yourself in the trail cam video. And the peeping Tom, and I'm gonna, okay, y'all can come back up now. Are we good? Okay. Is important as a charge. And you can see how scared she was and frightened in that video. She was unnerved about what happened to her. She's in the shower. And that's when he decides to try to open her door. Again, he had been outside her apartment for an hour. The testimony from Sergeant Rabu, and you saw this video yesterday from GBI Cyber, he first appears on the trail at 6:52 a.m. according to that trail cam video. Guess what that coincides with? His digital profile from the FBI. His phone is moving at the exact same time that you see him on this video for the first time. And what this does is, it is a crime, and he is guilty of that crime, but it shows his state of mind. You watched the video yesterday. He's there for an hour. You see students kind of mulling around, some of them waiting for the bus, a lot of them on their phones. He is not pressed. He doesn't care. He talks to no one. He interacts with no one, and he keeps circling back and forth from Tasia Sweet's door to the back of her apartment, Tasia Sweet's door to the back of her apartment. And he does it 6 times, and he tries to open her door at least twice that we can see. And when she says he is ducking, there's her window. You've seen that image as well. Here is the part of the video at 7:54 a.m. You see him ducking. She is absolutely correct. And what's he wearing? He's wearing the hoodie, a black hat, black gloves, and carrying a cup. His digital profile puts him right over her apartment at these pertinent times. His Reuben data is collecting at this point because he's not in the forest. And so it's him because of that as well. His digital profile puts him there. He's wearing the same clothes. But if you have any residual doubt that that's him in the video, boom. His DNA is on the cup. The white cup that you can see him carrying in that video was found smack in between Tasia Sweet's apartment and Laken Riley's body, and it is his DNA on that straw. And yes, it's a mixture. It's not Diego's, it's not Argenis's, it's not anyone related to him. It's him and some other male. And there's alcohol in that cup. He's drinking alcohol at 7 o'clock in the morning while he's out prowling and hunting females. It's him. No doubt that it's him. And I want to talk about the gloves, because the gloves that he chose to wear that day, you heard from Alexander Coven of the Crime Lab. Luckily, again for us, they were cheap. They're not latex. They're some kind of polyethylene, like plastic gloves that tear easily, is what he said. That was his scientific testimony. And those gloves were torn. And you saw photographs of them where Katrina photographed them at the crime lab. And because those gloves were torn, he was able, and maybe they were not torn when he was holding the cup, maybe they got torn when he's holding these rocks and murdering Laken Riley when she is fighting him. But at some point they were torn, and we know that because after they're recovered in the bushes, they go to the crime lab and they are photographed and they are examined. And the first person who sees them at the crime lab is Valencia Johnson, and she says they were damaged. The second person who sees them is Katrina, and she photographs them. And you have the photographs and evidence to use. You can see for yourself that they were damaged. So what in the world is he doing outside a co-ed's apartment, wearing plastic kitchen gloves, a hoodie, covering up his face, and skulking around? He is trying to get her. And when he couldn't get her, he ran away into the forest, and he stayed there until he encountered Laken Riley about 73 minutes later. And then he did all of the things that we've already covered in the indictment. And I want to talk to you a little bit about circumstantial evidence, but not in a way that I would talk to a jury about it. There is no legal difference between circumstantial evidence and direct evidence. It's not bad, it's just different. And in this case, it is powerful. And it is layered upon layer upon layer. And there is no way out for him. He is guilty of everything in the indictment. I want to talk to you about the defense case. And this is actually something that a scientist said yesterday. It's amazing how trials are, how people say things you never expected, and they just have a life of their own. Trials. Ashley Hinkle yesterday, I think it was on Cross. The absence of evidence is not evidence of absence. I couldn't say it better myself. I suppose their defense is Diego did it, because that's all we've been talking about is Diego. And yeah, Diego was a suspect because he's wearing the hat that they saw. But eventually, you know what the officers didn't do in this case? They did not turn a blind eye. They got Diego's phone, they got Diego's DNA, they interviewed Diego, and they followed it to its natural end. They looked through hundreds of hours of video. You saw the chart that Detective Norris put in on Friday of all the videos around the IM fields. And there were multiple cameras. He and Sergeant Rabu and Special Agent Lucas Beyer, they watched hundreds and hundreds of hours of videos. Guess who's not anywhere near the IM fields at the time and on this day? Diego. He is nowhere to be found. And the only way that Diego could have done this crime, and the only way that it could be even like a reasonable hypothesis that he could have done this crime, is if he had two things. Number one, magic pixie dust. He would need the magic pixie dust to put his brother's thumbprint on her phone. He would need the magic pixie dust to put his brother's DNA underneath Laken Riley's fingernails. And he would also, in addition to that, because of the video evidence, he would need one other thing. And that would be Harry Potter's invisible cloak. He would have to put that on and go to the IM fields and do these things because nobody sees him. And I want to talk about Stephanie, because what your decision is today is it's Stephanie versus science. Stephanie, who wants to invoke the fifth when asked about whether she had a sexual relationship with Diego, which goes to her motive for being here. And the conversation, which is so interesting, that she said she had with Diego on the night of the 22nd, after the police were in her apartment, and we know it had to be the night of the 22nd because it was after Laken Riley's body was found, which was noon on the 22nd. But before 8 a.m. in the morning, when Sergeant Johnson sees Diego wearing that hat that his brother left in the apartment after killing her, and she says between that time she had a conversation with him at some point. Well, guess where Diego was that day on the 22nd? You saw it for yourself. He was at work. And he was at work till about 11 p.m. And it was Stephanie's birthday, and she was out drinking. And she drank so much, Judge, that she even said, and the GBI, Annie Mormon, confirmed, she was drunk when she was talking to the GBI the next day still. And maybe she did have some semi kind of conversation with him. And even then, if you take her at her word, it's not a confession. There is no evidence that he did anything except be a brother to him. And it's pretty low down that you're going to take the killing hat and then let your brother wear it around in the apartment complex the next day. But that's just what a killer would do. So to believe her, you would have to disbelieve all of that. And then today we heard some unreliable inmate hearsay. Not reliable. And cannot weigh anything against the mountain of forensic evidence, video evidence, and digital evidence that you've heard in this case. And yes, here is Diego wearing that hat. You think he'd have worn that if he had known what was on it? He didn't know. Glad he wore it. He didn't know. And so that completes my portion of this closing argument, and I will see to defense and see Your Honor at rebuttal. Thank you.
Respect.
Your Honor, Ms. Ross, evidence that is subject to more than one interpretation is not proof beyond a reasonable doubt. As Mr. Kirby said in his opening, the evidence in this case is graphic and disturbing, and it is deeply sad. And I don't envy your position, Your Honor. The rest of the people in this courtroom get to be human. We can feel shock and outrage. But Your Honor, as the court, you are the embodiment of law. And as the court and the fact finder, the law requires that you not allow your verdict to be swayed by sympathy for anyone. It must be based on the evidence. Mr. Ibarra, acting on our advice, elected to have a bench trial, trusting that Your Honor could, and believing that Your Honor would, set aside the emotions in this case and simply consider the evidence. So I'm going to catalog for Your Honor why I think the facts and the evidence in this case should leave you with some reasonable doubt. Before I do, I want to touch on two legal principles. Your Honor is already familiar with them, but I do want to make my legal arguments clear for the record. The first legal principle is embodied in OCGA 2446. And that law requires that when the state's case is built on circumstantial evidence, they have a higher burden. They have to go one step beyond proving their case beyond a reasonable doubt. They also have to exclude, beyond a reasonable doubt, any other theory consistent with Mr. Ibarra's evidence, in a sense. Because the evidence is subject to more than one interpretation, it is not proof beyond a reasonable doubt. And while the evidence in this case is voluminous, it is circumstantial. The second principle is the difference between a party to a crime and accessory after the fact. This principle is codified in OCGA 16-1050, and I would also direct Your Honor's attention to Purvis versus the state. Purvis is the P-U-R-V-I-S. That is 208 Georgia Act 653. And that case basically explores the difference between proving that someone is involved in a crime while it is committed versus proving that someone is involved in the cover-up of a crime. The important difference, Your Honor, is that if the evidence shows that Mr. Ibarra was involved in the cover-up of the crime, but does not prove beyond a reasonable doubt that he was involved in the murder itself, Your Honor would be authorized to find him guilty on the tampering with the evidence charge, but not with the murder. So now I want to talk about the evidence that was presented. First, I'm going to discuss the reasonable doubt in the state's case that Mr. Ibarra was involved at all. Then, I'm going to discuss two alternative theories that are consistent with the evidence that would show Mr. Ibarra is not guilty of the malice murder or the felony murders. And then finally, I want to discuss a few specific elements of a few crimes and the evidence we've heard on those. The state bases its case in chief on some categories of evidence. There's DNA, there's a fingerprint. They talked about the digital evidence and the surveillance footage. There is reasonable doubt in each of those pieces of evidence. I'll start with the DNA. There is doubt based on what was tested and doubt based on what was not tested. When Ashley Hinkle was on the stand testifying and Mr. Kirby was cross-examining her, she talked about the limits of her science. She talked about the fact that some of the factors involved in testing for DNA are controlled by humans and some are run through a program. She decides how many people's DNA is on an object and then asks True Allele software to compute from that number of people the likelihood of whose DNA that is. Her decision impacts how the test is run. She told you that there is an element of randomness in True Allele, and that if they run the same test multiple times, different probabilities will come out. And that's what happened in this case. Your Honor should be skeptical of the DNA evidence also because of something that Ms. Ross talked about. A hat that we know for certain was on Diego, a hat that we know for certain was his hat that he claimed. Nothing on that hat tested positive for his DNA, which goes to show that even if someone is wearing clothes, touching clothes, owning clothes, DNA is not always going to show up when the lab tests it. People in court wore gloves when they handled this evidence because they were afraid of cross-contamination. They were afraid that their touch would impact the reliability of future DNA tests. When you look at the apartment from which these clothes were taken, that is a lab tech's nightmare. There are clothes everywhere piled together. It's 5 people living in one room. And the state's theory is that they shared clothes. Of course their DNA is going to be on each other's clothes. It's more than possible that one brother's DNA would get on another brother's clothes. In fact, it's probable. And who would have had the most cross-contamination? Diego and Jose, because they shared a bed and they shared clothes. When it comes to True Allele, I do believe our argument is hampered by not having an expert, but there are clearly flaws with that testing system. One of the tests that they ran for the evidence in this case came back to a retired GBA agent who was not involved with the testing of the case and was not in any way could have had their DNA on that object. There's also doubt based on what was not tested for DNA. There was a bloody thumbprint on Laken Riley's phone that they believe was placed there by the killer. And they chose, rather than swabbing that for DNA, they chose the less reliable scientific method of fingerprint evidence. There were no swabs tested of the phone, even though Saunders testified that they did take swabs. There were no swabs tested from Laken's neck and torso. But perhaps the most important is that they swabbed Jose Ibarra's hands and his fingernails. And their theory is that his gloves ripped enough for him to leave a fingerprint on a phone. That rip would have allowed him also to have contact with Laken Riley's body. And then, if they had tested the swabs on his fingerprints, we could have seen if Laken Riley's DNA showed up on his hands. But they did not. They don't get to cite a name of a guy we don't know, James Sebastian, and call it a day. They should have provided some reason why they didn't test these swabs, and they gave Your Honor none. They also didn't test any of the gloves found in Diego's bag. They had a visual examination, but we know from the state's own evidence that that's not enough. Katrina Ostapovich testified that she has to use a special light to see blood on objects. She called that light an ALS and compared it to a black light, because blood is not always visible to the naked human eye. So Saunders' visual examination of the gloves in Diego's bags should not persuade Your Honor beyond a reasonable doubt that they did not have blood on them. The fingerprint evidence in this case is also questionable. At the Daubert hearing, Tim Stewart testified about the APHIS database, and that is a federal database that stores any fingerprints deemed valid enough for comparison taken by federal agents. There are hundreds of thousands of people in that database. And Tim Stewart, before he did his own comparison, ran the latent fingerprint from the phone through that database. And there was no match to Jose Ibarra. He wasn't even in the 120 possible candidates that APHIS populated for Tim Stewart. I want to also speak briefly about confirmation bias. When we were speaking to the medical examiner, she talked about how when she looks at the case, there's information already populated in the system that she doesn't generate. The case number and the involved parties. And the involved parties in this case are telegraphed to the scientists at GBI as to how the state wants the evidence to come out. The information said subject Jose Ibarra and elimination Diego and Argenis Ibarra. And unfortunately, when you're testing for DNA and you know ahead of time the result you're supposed to get, that colors the process and weakens the scientific reliability of those DNA tests. Now, as the phone location data, their theory is that Jose had the phone. Agent Hipkiss testified that Jose is the user of the phone. Their evidence relies on the fact that Jose had exclusive access to that phone, but that is dispositively not true. Norris testified that other individuals were communicating with other members of someone using that phone in October. The stipulation of the parties showed that there were other accounts on that phone. There were 2 Gmails belonging to Diego, and there was some evidence that that email account was active in January of 2024, which is a month prior to this. Rose Bailey had a Facebook Messenger account on there. Jose's mother-in-law had a Gmail account on there. There are multiple Instagram accounts belonging to Diego on there. That's all stipulated. And even if you consider that Jose had the phone, the testimony of Jay Burney shows that there is some shakiness as to exactly where that phone was at the time of the murder. The broad band of where that phone could have been due to the delayed timing evidence of the phone is quite wide. It covers parts of the Oconee Forest and parts that are outside the forest. He concluded that the user of the phone must have been in the forest because of the lack of Wi-Fi Reuben data, but he also conceded that that Wi-Fi Reuben data could have been lacking if someone turned off their Wi-Fi. That uncertainty as to what caused the Wi-Fi to not respond is reasonable doubt. In the dumpster video, Your Honor should have some doubt based on the angle and the quality of the video. Rose Bailey did identify Jose, but she testified that the reason she identified him was because of the hat and the shoes. The hat that we know Diego owns, and black slides that we know Diego owns too, because the agents found a second pair of black slides in the apartment when they searched it. So the hat and the shoes that Rose Bailey identified for Jose could just have easily been Diego's. In the 911 call, no one identified the voice. I don't know why the state didn't ask Rose Bailey, but she was here. Maybe she could have testified of who was speaking, but no one did. And the phrase that the state would like you to believe is being spoken, yo tango, was heard by somebody who does not speak Spanish. We don't know what is being said on that call. We don't know who says it. There is an alternative theory in this case that makes sense of some of the discrepancies in the state's case. Jose was short, he was chubby. He was, according to the state, wearing slides the morning of February 22nd. I agree with the state that Laken Riley was physically fit, she was fast, she could have outrun him. But there's another suspect in this case who was taller, who was more physically fit, who was wearing sneakers on the day of the murder, and that is Diego Ibarra. We know from the dumpster video that the person throwing away the jacket is tall, because Officer Zach Davis testified the slot into which the jacket was thrown was about 6 feet high. The person in the video didn't have any trouble, it was parallel to their head or just above it reaching that slot. That suggests someone that's taller than Jose Ibarra. We also know from Joseph Clemente that there was a second person out wearing dark clothing, not a runner, on the day of the murder. He testified that between 9:46 and 9:48, he saw somebody who was skinny, wearing dark clothing, wandering around the intramural fields, and was about 6'9" or taller. That description matches Diego to a T. And we know it can't be the same person in the dumpster video because it happens at the same time. The dumpster video is at 9:44. Clementi is pretty certain about his timeline because he's tracking his position using a running app on his phone. Other evidence that suggests Diego is the one who killed Laken Riley is, of course, that the fact he was wearing the hat with Laken Riley's blood on February 23rd. According to the state, you can see blood on black clothes, so Diego, when he's choosing hats that morning, should have been able to see that the hat was bloody. But more importantly, Officer Epps testified that he observed dirt on the brim of the hat. Tim Johnson testified that he observed dirt on the brim of the hat. There is no way Diego put on that hat without noticing something was strange about it. And the reason he put it on, without questioning why it's got dirt and blood all over it, is because he already knew that it was there. The state would like to say that Diego would have to be the dumbest killer in the world to put it on, but unfortunately for the state, that's exactly what the person in the dumpster video does. After he examines the hat, he puts it back on. So if their theory is that's Jose, or that's Diego, either way, the killer put the hat back on his head after having been committed in a murder. So that argument does not hold water. We know that Diego had 2 cloth gloves in his bags. Both of them were mismatched, meaning that, assuming that they each had a pair, there was a pair of gloves Diego owned that was never found. But while we're talking about gloves, I want to talk about the black gloves that were found in the apartment. We know that they were disposable kitchen gloves, and unfortunately we don't know where they came from because the officers didn't track the investigation that far back. However, Rose Bailey said that they did not come from Utah Jail, the sushi place where Jose and she worked. They did not come from the place that Jose Ibarra had access to. What we cannot rule out is the Bolton Dining Commons, the UGA dining facility where Diego worked. Why is that important? Because bringing the gloves home shows a step of premeditation. Who had access to do that? Diego. Why would he do that? Because he was planning to use the black gloves at some point. And speaking of gloves, why are there 3 of them found in the bushes? Jose has 2 hands, like everybody else, but there are 3 gloves, and they test all 3 and found presumptive blood on all 3 of them. What that suggests is that there are multiple pairs of hands wearing those gloves. Now, they did enter video evidence of Diego clocking in at work, but that video is not an alibi for Diego because his commute to work was only 10 minutes, and his clock-in time on February 22nd is 3:57, which is 6 hours after the murder. If anything, Diego's work schedule makes him more suspicious because the bus stop that he regularly takes to work is the one featured in the surveillance video near Saraswati's apartment. It is the same bus stop that the officer said they reviewed and never saw Diego. And we know that they should have seen Diego because he took that bus stop to get to work that day, which means the detectives never saw him because they missed him at least once, possibly more than once. We know that Diego's phone had no service, no location capabilities, and the agents testified that Jose's phone was a go-kart to Jose's race car. If Diego needed to use a phone with service, the phone that's already logged into his Facebook, Instagram, and Gmail, he would have taken Jose's. The state argued that Diego didn't act suspicious. Neither did Jose. Both of them complied with police commands. Both of them answered questions and were talking, laughing outside the apartment. Officer Cyan testified that the vibe amongst all the roommates was relaxed. They were smoking cigarettes. You can't assume anything good from Diego's behavior on February 23rd that you can't also attribute to Jose. But it goes beyond the possibility that Diego was involved. Diego himself, multiple times, confirms it. First, by threatening Stephanie Slayton. Now, Ms. Slayton has no incentive to lie, and the state did a lot of work trying to make her look uncredible. And I like that the state is not about shaming females until they're testifying in a way that complicates their evidence. Because they tried to use her sexual relation with Diego to implicate her involvement. They've tried to shame her for celebrating her birthday. But the truth of the matter is she was scared and she came forward to the police anyway. She talked to them multiple times. She offered to let them download her phone, even though she was fearful of retaliation. Those are not the actions of someone who is making something up. In the context of that conversation that Slayton was talking about, she tells Diego, I know you're in that area a lot. You must have seen something. You should tell the police. And that's when he said, if you tell them that, like I was in the area and I might know something, I will tell them that you did it and then I will kill you too. Why is the two important? Because it's implying that he has already killed before. But Slayton is not the only one who has heard statements from Diego that implicate his involvement. Your Honor is aware that there are inmates who have heard Diego say that he was wearing the blue jacket on the day of the murder, that Jose threw it away in the dumpster, presumably for him. He told them that Jose didn't do it, and the police weren't looking carefully enough at the evidence. He put himself on the scene and told those inmates that he saw Laken Riley's body. Your Honor, it's obviously going to be thinking, well, how did Diego then not show up in the DNA evidence? He might have. We know that there were multiple male profiles on the straw. They said it couldn't be a blood relative because of a YSTR straw, but we know that Diego was not a YSTR comparison from the fingernails. So that could have been Diego on there. And as Ms. Hinkle said, the absence of Diego's evidence is not evidence of Diego's absence from this case. Some of the minor profiles on the gloves and the hat were not identified. And the true allele ratios that the state relies on said that the DNA was more likely to be Diego's than Argenis'. Another theory of the case that is not excluded by the state's evidence is that Jose was an accomplice after the fact of the murder. Maybe it was him throwing away the jacket, as Diego said. Maybe he was covering up for his brother. Maybe one of the two men in the area went to the dumpster and one went to the retainment pond at 9:46, which is where Joseph Clemente saw somebody standing. Maybe one of them dumped clothes in a dumpster behind the apartments, and maybe one dumped clothes in the woods, where Officer Krischer found clothes exactly in that area that were not tested because they didn't fit the simplistic narrative of the state. Maybe there were two men involved in covering up Laken Riley's body, which is why there were 3 gloves recovered in the bushes. 2 people wearing 2 gloves, and we just don't know what happened to the 4th. To explain why there are 2 rocks in this case. We know that Jose was looking for Diego on the morning of February 22nd, because Agent Hipkiss testified that at 2:30 in the morning, there's a missed call from Jose to Diego. So there is some evidence that he was looking for Diego. The Spanish phrase in the 911 call could be Yo Tango, but it could also be the name Diego. That could be Jose saying his brother's name. Under that theory, of course, Jose would be guilty of tampering, but that theory does not prove that he was present or involved in the murder of Laken Riley. I want to speak last about 2 specific charges, aggravated assault with intent to rape and the peeping Tom charge. Their basis for concluding that the aggravated assault was intent to rape was the state of the clothes and the markings on her body. But Maxwell, the officer who found Laken Riley, testified that the area where he found Laken had vines and thorns. He testified about those catching on his uniform as he walked around looking for her. And they also, so it could have been that she was cut up by the vegetation in the area. We know that she unfortunately was dragged at some point because the scene where the blood is separate from where her body was found. So the scratches could have come from her being dragged to another area. And we also know it's unlikely to have been the scratches of her assailant from the fingernails, if that assailant was Jose, because when Daniela Stewart went to take his fingernail clippings the day after the murder, they were too short to take any clippings without having cut into the quick and being very painful. So it's unlikely to have been Jose's fingernails that caused those scratches. We also know that she had bloody marks on her ankles that didn't correspond to the wound, which suggests that somebody with bloody hands grabbed her ankles and used that to move her. And that could explain how her clothes were pulled up in that dragging position. We know that there was a struggle. We know that Miss Riley fought. Somehow her clothes could have ended up twisted in that struggle. And lastly, the intent to rape is a very specific intent. It's not just an intent to sexually assault someone. It's not just an intent to look at someone. It's not just an intent to expose their breasts. It has to be the intent to commit the legal definition of rape. And in this case, there's no evidence of trauma, according to Dr. DeMarco, of anything like that having happened or even attempted to happen. As far as the peeping Tom, the only part of the evidence I wanted to highlight for your honor at this point is that when Ms. Saraswati identified someone looking into her apartment, she said she never saw any part of his face, only the rim of his hat. So I think there's reasonable doubt that someone was actually able to look in. It may have just been the hat that was visible to Ms. Saraswati. Just one moment, your honor. Evidence that is subject to more than one interpretation is not proof beyond reasonable doubt. I would remind your honor that even if you think the alternative theories of the evidence are less likely, but they present any reasonable doubt, you would still be required to find Mr. Ibarra not guilty. We ask that your honor apply the exacting standard of the law to these facts and find Jose Ibarra not guilty. Thank you.
Ms. Ross?
So what we just heard really is magic pixie dust defense. It is not reasonable, it is not supported by any evidence, and it is desperate. And it is a combination of a break with reality and mischaracterization of the evidence. And I can just give you a few examples. They did not report, the GBI did not report that someone else's DNA who used to work at the crime lab was in any of these items of evidence. That was not the testimony at all. The testimony is that they have a validation for true allele, and if any amount was a 4% contributor or falls below their threshold, those are not reliable results, which is how they compensate for the known error rate of true allele. The GBI will not report results below the known error rate of true allele. Every single result in this case that is before your honor is reliable, reproducible, and validated. That's why they reported it. If it were not those things, they would not have reported it. And then let me give you another example of the desperation. Well, the straw could be Diego's. No, it can't. It wasn't a YSTR result with the straw. It was a true allele result. And it was this defendant's DNA on the straw with a mixture of someone who the expert testified is not a male relative. He could not be on that straw. So what we have heard is truly a mix between mischaracterization of the evidence and the magic pixie dust defense. There is no reasonable explanation for all of this evidence other than he is guilty of every single count in this indictment. And the you should acquit him because Tejasvi only saw the rim of the hat. That completely ignores that there is a head on the hat. That is desperate. And she said herself, he peeped. I see him peeping in my window in the body cam video. He is guilty of that, which shows his state of mind. And her aggravated assault intent to rape truly is what I thought it would be, which is he killed her, but he didn't try to rape her. Her underwear is torn. And I know Your Honor is an experienced jurist. There are multiple cases out there in the state of Georgia that disheveled clothing alone is enough to support a conviction for aggravated assault with intent to rape. But we have more than that because we have his motive 73 minutes before, and we have the evidence of her clothes going in two separate directions. So those are, as my old trial partner used to say, just ink in the water. That's just to distract the court. The defendants, our evidence isn't based upon him having exclusive access to the phone. We never said that. She said that. What we have said is he had the phone that day, and there's no evidence to contradict that testimony. In order for you to find him not guilty, you would have to ignore all the evidence. They're saying, don't believe the DNA, it's not reliable. Don't believe the fingerprints, it's not reliable. And by the way, Tim Stewart covered in the the Daubert fingerprint hearing that it is not unusual to not get an APHIS hit, but still do a hand-to-hand comparison and have a match. And his results, if you're at least a bit skeptical about them, and you shouldn't be based on his experience and his training and the methodology and the board that he created and how he explained how he got there, were blind peer reviewed by another completely different examiner who came to the same conclusion. This is reliable evidence. It's reliable forensic evidence. And then they're like, oh, well, don't believe the digital evidence because you can't believe that either. There's no reason for you not to believe all the evidence in this case that's been put before you. And when you look at all of it together, it has only one reasonable explanation, is that he is guilty of everything in this indictment. And for the past week, Miss Jackson and I have been fighting for Laken Riley every day in this courtroom. We're done. Our work is done. And we turn this case over to you to make a decision on all of this evidence in this case. And we are asking you, in your decision, to render a verdict that speaks the truth about what happened that day, on the 22nd day of February, 2024, when this man took the life of an innocent woman, just going about her business, living her best life for no reason. It's senseless, and only you can end it. We're asking you to find him guilty of every single count in this indictment, to bring justice to Laken, her family, her friends, Tejaswi, and your entire community here in Athens. Thank you, Your Honor.
You all want to review the verdict form again. It's the same one you looked at yesterday, but you're welcome to look at it again. We'll take a 15-minute recess.
All right, a couple of things before I announce the verdict. I want to point out that typically my role in a trial, in a criminal trial, is to manage the process. And the fact finding is done by a jury. That wasn't the case in this trial. I managed the process, try to, and I was also the finder of fact, and that is somewhat of a different role than we typically see. I'll tell you that you may have seen me, I make notes during the trial. I probably filled up 2 legal pads full of notes during the trial, but the closings I want to just listen, and that's what I did. But I wrote down 2 things in the closing. One was a statement by Ms. Ross that the evidence was overwhelming and powerful. And then I also wrote down what Ms. Beck said, that I'm required to set aside my emotions. That's the same thing that we tell jurors in what and we're giving them their job. I would that's the way I have to approach this, and I did. Both of those statements are correct. I'll now announce the verdict. In the state of Georgia versus Jose Antonio Ibarra, case SU 24 CR 0323, count 1, malice murder. I find the defendant guilty. Count 2, felony murder. I find the defendant guilty. Count 3, felony murder. I find the defendant guilty. Count 4, felony murder. I find the defendant guilty. Count 5, kidnapping with bodily injury. I find the defendant guilty. Count 6, aggravated assault with intent to rape. I find the defendant guilty. Count 7, aggravated battery. I find the defendant guilty. Count 8, obstructing or hindering a 911 call. I find the defendant guilty. Count 9, tampering with evidence. I find the defendant guilty. Count 10, peeping Tom. I find the defendant guilty. I certainly will allow both sides to look at this if you want to do it. The next step is sentencing. I'm prepared to go forward with that now, or if either side suggests that you need a few minutes, an hour break or something to do that, then I'll certainly do that as well. Consider that.
We have one moment.
Sure. I understand.
We'll come back for sentencing.
I understand. We will recess till 12:30. Recess till 12:30. Will that work?
Yes, sir.
Okay, thank you.
like to present victim impact testimony to his honor, and then I will proceed with talking about merger or issues like that in the sense that the state would be seeking. But I'm going to go at this time and call the witnesses up who wish to be heard for victim impact. So first I would like to call Allison Phillips. And why don't Allison, John, and Lauren come on up together, the three of you. And defense counsel has agreed that there's no need to swear the witnesses for the statement. If you could come over here, Ms. Phillips. So before the court, Your Honor, first will be Allison Phillips, and she's Laken's mom. Behind her is her husband and Laken's stepfather, John Phillips, and then their daughter, Laken's sister, Lauren.
Your Honor, on February 22nd of 2024, our family and friends were given a life sentence without a chance of parole. Jose Ibarra took no pity on my scared, panicked, and struggling child. There is no end to the pain, suffering, and loss that we have experienced or will continue to endure. On that horrific day, my precious daughter was attacked, beaten, and shown no mercy. She fought for her life and dignity and to save herself from being brutally raped. This sick, twisted, and evil coward showed no regard for Laken or human life. We are asking that same be done to him. Laken had a beautiful and bright future. She was smart, hardworking, kind, thoughtful, and most importantly, she was a child of God. She had a personal relationship with Jesus, and she loved being the hands and feet of his hands and feet in this world. She shared her love for our Lord with others through her mission trips, working with elderly at the nursing homes, and through her nursing career. Laken was an amazing friend, sister, niece, daughter, and granddaughter. Anyone who knew her knew about her loving heart. Laken's life was not the only life taken on that day that Jose Ibarra attacked her. The life of her family and friends was taken too. None of us will ever be the same. This monster took away our chances to see Laken graduate from nursing school. He took away our ability to meet our future son-in-law. He destroyed our chances of meeting our grandchildren. And he took my best friend. He ripped away every beautiful memory we will ever be able to make with her again. This horrific individual robbed us all of our hopes and dreams for Laken. Your Honor, I'm asking you to please give Jose Ibarra the same thing he gave us when he made the choice to take Laken's life and destroy ours. He showed no mercy on Laken when she was begging for her life. There's no end to the pain and suffering that he inflicted on our family and our friends. I'm asking you to please give this monster life without any chance of parole so that he never gets the chance to hurt anyone else ever again.
This is John Phillips, Ron.
I'd like to thank Your Honor for the opportunity to speak today. I truly appreciate it. I heard in the opening statements from the defense that the loss of a life that was apparently full of promise is tragic. Well, I'm here today to let Your Honor and the entire world know that Laken's life was not apparently full of promise, but instead was abundantly and exceptionally full of promise, and was a shining beacon in the life of everyone that knew her, that ever came in contact with her. I'm so proud of Laken and the beautiful person she was. And while I could stand here and try to tell the world the things that made her such a wonderful person, as well as the many things we have all been robbed and deprived of, I think one of her last journal entries dated 12/17/23 says it best. So here we go. To my future husband. As silly as I feel writing this, my old small group leader once recommended it, so here I am. To my future husband, I want you to know that I'm thinking about you. I'm working every day to become the best wife I can be, by working through my current relationships to best prepare me for ours and our kids one day. I'm focusing on God and what He defines as a faithful Christian life, and so that I can best embody those characteristics. I pray that you know that it is with my full faith and trust in God that I know this relationship has been handcrafted by Him. I pray that we continue to glorify the Lord, prioritize Him in every aspect of our lives, and raise our family, our future family, to be God-fearing Christians as well. I pray God is the center of our relationship as it is a gift from Him. I thank Him for you before I even know you. I can't wait to love you in the best way I know how for the rest of our lives. I pray you know and feel the importance of my love and hopes for our relationship. No matter what challenges we face, I pray that our trust in God and love for one another overrules the obstacle. May our relationship last forever. Your future wife, Laken. That, Your Honor, was our beautiful Laken. That, Your Honor, is just a glimpse of what was tragically and brutally taken from her and us that day. The best daughter, sister, granddaughter, friend, and overall person that you could ever hope to meet. While it's true that none of our lives will ever be the same, we refuse to let this person rob Laken of the hope she gave to her family, loved ones, friends, and the world as a whole. We will proudly carry this hope on in her name in the days ahead and for the rest of our lives, because together we can all keep hope alive. So today, I plead with this court to protect the world from this truly evil person by sentencing him to prison for life without the possibility of parole for any reason, so that he can never have the opportunity to do this to anyone else ever again. Thank you, Your Honor.
Next, Your Honor, is Lauren Phillips.
Your Honor, I wish I could truly put into words how much the tragedy that occurred on February 22nd, 2024 has affected me, but I don't think I'll ever be able to do so. With that being said, I'm going to attempt with the best of my ability to do that for you today. My name is Lauren Phillips, and I have the amazing privilege of living with Laken Riley as my older sister. Laken was and will forever be my most favorite person. She was my biggest role model, and I looked up to her in every way. She brought the joy that I needed into my life and never failed to make me laugh. There was absolutely nothing that I wouldn't do for Laken, and nothing that she wouldn't do for me. Laken was my biggest protector, and I always had this sense of comfort and safety in her presence. We have been inseparable ever since the moment I was born, and I've been lost ever since she was senselessly stripped from our lives by Jose Ibarra. I now have this hole in my heart and in my life that I know will never be filled. I had to walk the stage of my high school graduation without my biggest supporter and cheerleader in the crowd. I had to finish my senior year of high school, which most would say is the happiest and most surreal part of your life. It was simply the opposite for me. I had to turn 18 and become an adult without the one person I looked up to there by my side. I had to get accepted into my dream school, the University of Georgia, without my sister telling me how proud of me she is, and finally getting to live in the same town together again. I now have the burden of dealing with the fact that my best friend and sister will never come home again. She'll never send me another daily good morning text, funny TikTok, or silly Snapchat. The true sense of joy I felt when she would randomly surprise me will never happen again. I will never get to hear her infectious laugh or see her light of a smile ever again. I now get to explain to people when they ask me if I have a sibling that I no longer have one, and not just because she passed away, but because she got brutally attacked and murdered. I cannot walk around my own college campus because I am terrified of people like Jose Ibarra. My parents will never be the same after losing their daughter in this tragic way. Seeing their heartbreak is excruciating. We were once a happy family of 4, and now there is an evident hole where her presence is forever felt. We are a broken family of 3, struggling to find out how to live this life through the silence and emptiness that her absence has left behind. The joy that she brought to our home has been completely replaced with grief, and we are just left holding the pieces of a life that will never feel whole again. She will not get to be at my wedding and next to me as my maid of honor. I get to deal with explaining to my future children what happened to their Aunt Laken and why they won't ever be able to get to feel her love or be spoiled by her. All of these experiences were and will be stripped of me against my will, and I now live in a constant state of fear, anger, and sadness. I think about how my sister saw exactly what was coming and had no way of preventing it. I think about how scared she must have been and how that man is the only one to truly witness that scene. I'm not sure why he did this to my Laken, and I know I will never understand. I've waited for him to have a reason, but as the details of this case have unfolded, I realize I'll never get any peace or closure. What Jose Ibarra did to my sister is almost unbearable to listen to. I am completely disgusted having to even look and be in the same room as him. That predator is inhumane and is the epitome of evil. I have no doubt in my mind that the monster sitting in this room with us today is the same monster that encountered my precious sister on February 22nd, 2024, where he proceeded to attack, assault, beat, murder, and attempt to rape her. Jose Antonio Ibarra has completely and utterly ruined my life, and I can only hope and pray that he receives a sentence that ruins his. Thank you.
Your Honor, I stand here today as a grieving father whose heart was shattered in ways I never thought possible. My daughter, Laken Riley, was not just our child. She was the light of my life, the person who brought joy to every room she entered. And now that light has been extinguished forever, taken from us in the most senseless and violent way imaginable. The pain I feel is unexplainable. Every day I am reminded that my daughter is gone. I will never hear her laugh again, never see her smile, never hold her hand or feel her hug. She was taken from us, from her family, from her friends, from her future. Our world has been torn apart, and no matter what happens here today, nothing will ever bring her back. I am haunted by the thought of the fear she must have felt in those final moments, and it breaks my heart knowing that she suffered. I have to live with the fact that I could not protect her when she needed me the most. The pain of not being there, of not being able to stop what happened to her, is something I will never escape. My daughter had so many dreams, so many hopes for the future. She had worked so hard to become a nurse, to work with children and spread the love of God. She was a loving, kind, and intelligent young woman. She had so much to offer the world, and her life was taken from her far too soon. I will never get to see her achieve those dreams. The void that has been left is unmeasurable. The impact of her loss on our family is immeasurable. As a father, I am forever burdened with the pain of losing my child. I will spend the rest of my life trying to navigate this grief, trying to make sense of the world that took my daughter from our family. But I will never forget her. I will keep her memory alive, and I hope justice is served for her, not only because I'm her father, but because she deserves it. I ask that you consider this life that was taken, the pain that has been caused, and the lasting effects of this tragedy on everyone who loved our amazing daughter, Laken Hope Riley. Thank you.
Lily Steiner, Sophia Magana, Connolly. Connolly's on the first row.
Good afternoon. As I stated in my testimony, my name is Connolly Huth. Laken Riley was my roommate for 2 years, my devoted and loyal running partner for 2 years, and my best friend forever. I stand before you looking at you through eyes that have seen, ears that have heard, and a heart that has felt emotions no body, and especially no 22-year-old, should have to. On February 21st, my life was complete. I woke up on February 21st at 7:30 a.m., walked out of my bedroom door to streamers hung outside of my bedroom from the top of the door frame to the floor, balloons blown, decorations taped, and gifts presented precisely on my kitchen island. Laken did it. It was my 22nd birthday. She had a 5 a.m. nursing clinical, yet she woke up at 4:30 a.m. to make me feel loved and appreciated, because that is who Laken Riley was. I went to dinner that night with my roommates and my family, and ended the night with my roommates, and especially Laken, showering me with love. It is clear and evident that this defendant, Jose Ibarra, has never felt this type of love and appreciation. I've been impacted by this brutal cowardice and preventable tragedy in every way, shape, and form. I no longer have a best friend that I relay every thought or worry to. I no longer run every day. I lost my partner, and I lost the joy of what running was before Laken was taken from us. I cannot imagine running when I constantly am looking over my shoulder in public, wondering if I am next. I live with excruciating guilt every day that I was not accompanying Laken on this run, and that it was her and not me. And I hope and pray that it will never happen again to anyone. Along with this, the crime that this monster committed ruined one of the most special places in our friendship. Lake Herrick was Laken and I's safe space. We loved to go on running adventures throughout the park together. We had a code called dock time. Dock time consisted of either ending our runs or taking a calming walk to the dock at Lake Herrick. Here we would sit in silence, play music, or talk while sitting on the dock, simply enjoying each other's presence. All it took was a text saying, "I need dock time," and we were on the way to debrief whatever we needed to discuss. Now, when I think of this beautiful spot, I think of the terror and horror my sweet best friend had to endure at the hands of this monster. I think of all the things I have to do now to remember Laken. At times, I forget how she laughs or how she sounds, and I have to resort to looking through my camera roll of hundreds of videos I have. Videos where I talk to my future kids and introduce them to their Aunt Laken in college. To talk to my friend, I have to drive 20 minutes to her grave and sit and talk to her with no response, screaming at the sky. When I want to remember her, I have to go to my closet and pull out her clothes I was given and smell them to remember how she smelled. As I stand up here today, I am wearing one of Laken's shirts. This shirt has sat in my closet for months, not because I'm saving it for an occasion, but because I cannot afford to not remember these things like this about her. I sit in therapy week after week trying to heal February 22nd and life after. When I hear emergency vehicle sirens, I am triggered. I sat that day and watched dozens of emergency personnel drive by as I sat helpless. My roommates and I had to draw our own conclusions that the pinnacle of our house was no longer here when we watched a coroner drive by us after sitting at the fields for 2 hours with no answers. Our fears were confirmed when we received a university-wide email that alerted students, faculty, and staff that a female was deceased. I lost faith in humanity the day that my kind, selfless, beautiful, smart, loving, and perfect best friend left this earth. I will never understand why it had to happen in the first place, but more importantly, why out of all people it had to be her. The world lost a girl who would take the clothes off her back for her family, friends, and even strangers, who studied and devoted her life to Christ and nursing so she could save lives and make a difference in this world. Laken cannot be replaced. If you had the ability to bring her back out of all this, I would give up every earthly possession I have to see her infectious smile, hear her contagious laugh, and her infamous love you girl, and I would hug her neck, but you cannot. Laken made this world, and more specifically my world, better. My first years of college, when I did not know Laken, I went home all the time. My last years of college, you had to drag me home. That was because Laken was my person. So, Your Honor, I wish to proclaim the maximum sentence for the defendant, as I will never be the same, her loving, beautiful family will never be the same, and this world will never be the same. I hope this sentencing sets a precedent, so it stops with Laken and fails to happen to anyone again. Laken was a hero and a warrior, she died a hero and a warrior, and she is a hero and warrior to all of us. Laken was my source of light, joy, and unwavering happiness. So when her life was taken, so was the part of me that knew how to truly feel those things again. Thank you, Your Honor.
Lily Steiner,
Your Honor, my name is Lily Steiner, and as mentioned in my testimony, I was one of Laken's roommates, friends, and family. On the day of February 22nd, 2024, Laken Riley was taken by Jose Ibarra from her family, her roommates, her friends, her sorority sisters, her classmates, her future children, her future husband, and her future patients. This trial focused on the death of Laken, which has overshadowed the life that she lived, the life that was stolen from this community. Laken was the most driven student with the biggest heart of anyone I think I ever will meet. As roommates, we got to spend a whole lot of time together. We had our family dinners that were strictly chili. We watched Dancing with the Stars every Tuesday. We had almost daily Starbucks runs, which I hoped to do that morning when I checked her location around the time she took her final breaths. We'd often get to a point at least once a week where we'd get emotional, thinking about what life is going to be like once we graduated. Laken held a place in all of our imaginary futures. Now Sophia, Connolly, and I graduated in May, required to move on with our lives, while Laken can't. We have the privilege to get jobs and move to an exciting new city to experience post-grad life, but Laken doesn't. I'm currently working as a medical assistant, waking up every day dreading that I won't get a text from her to make my day better. I'm striving to work in the medical field, but I know I could never be half the healthcare worker that Laken would have been and that the world was deprived of. While living together, we often would play outside of our house in the middle of the street, specifically Foursquare, listening to a playlist I made called Playtime with My Family. Our home was such a special place to us, one that was tainted. Athens has never been the same, nor will it ever be. Shortly after Laken's death, I had to come back to UGA to finish my classes without Laken and without the safe space that we built together, and it was awful. Every time I wanted to go somewhere, I had to drive by the apartments that provided a roof over his head while he got to rip away ours. Life without Laken has been so dull, and having to learn how to navigate time without her through grief, anger, and fear has been beyond difficult. So many people are lost without her. Laken made her short time on earth so significant that she managed to impact those who she never even met. Laken left a colossal legacy to everyone she touched, and I have zero doubt that she is still not finished building it. And that is something Jose Ibarra will never be able to take away. I hope to never say his name again, but to shout Laken's every chance I get. I kindly ask your honor that you help us all in our long healing journey by allotting the maximum sentence for Jose that unfortunately still won't make up for the beautiful life taken.
Your Honor, my name is Sophia Magana. I'm Laken Riley's roommate of 3 years. I stand before you today with a heart full of grief, sadness, and an overwhelming sense of loss of my best friend. Laken wasn't just my best friend. She was my roommate, my sorority sister, and above all, she was my chosen family. The joy and kindness Laken brought into my life every single day could never fully be put into words. We confided in each other, supported each other through life's challenges, and celebrated our joys together. The loss of my best friend has shattered my world in ways I never thought possible. I never imagined that I'd have to navigate life without her by my side. Every day, her friends, family, and loved ones carry the weight of her absence, a weight that is heavy and unrelenting. Laken was my fearless other half. As someone who's reserved and awkward, Laken was always there to nudge me to step out of my comfort zone. She would pull me onto the dance floor and encourage me to try new things and remind me to live life to the fullest. I trusted her completely, and I always knew she was there for me, as I was for her. Those small, precious pieces of life that we once took for granted are now reminders of what I've lost. Laken taught so many people in her life invaluable lessons. She showed me how to find joy in every moment, how to embrace life with an open heart, and how to dance in a crowded room without caring what anyone else thought. These lessons will stay with me forever. Laken was not just my best friend. She was a devoted daughter, a loving sister, and a cherished friend to so many. She was an exceptional student with a bright future ahead of her, destined to become a nurse who would touch countless lives with her compassion and care. I miss hearing her laugh, seeing her smile, and hearing her voice, all of which brought warmth and light to all those around her. Now we are forced to confront an unthinkable reality. We will never again hear the joy of her laughter, feel the warmth of her smile, or find peace in the sound of her voice. The loss of Laken has left a hole in our hearts that can never be filled. The monster who took Laken's life has clearly never known love, like the love Laken showed everyone in her life. Love that was boundless. Love that was a testament to the amazing person she was. Jose Ibarra brutally attacked Laken. And now spaces that were once filled with joy and peace are places I fear for my safety. I now live my life in a fear, constantly looking over my shoulder with the new reality that the unexpected can happen. A world Laken taught me to embrace is now a world I feel unsafe in. Every day I put on a brave face as I step into my classroom, ready to teach and support my students. I mask my emotions and fears to shield them from the harsh realities of the world, preserving their sense of security and innocence in the world. Yet inside, I'm struggling, holding back tears until I can slip away to the bathroom or wait for the school day to end so I can finally let my true emotions surface beyond those four walls. February 22nd, 2024 is a day I will never forget. It is a day Jose Ibarra chose to commit an unthinkable act of murder Laken. He took from this world somebody who embodied love and light. Jose took my light, my sense of joy, my best friend, and my other half. Losing Laken has left an enormous hole in my life. The world feels quieter, emptier, and far less joyful without her in it. Her absence is felt in every corner of my day-to-day life, and I don't know how to fill the space that she once occupied. But what I do know is this. Laken's legacy of love, kindness, and friendship will live in all of us who knew her. The love she gave so freely will continue to guide me as I navigate this life without her. Jose Antonio Ibarra took Laken's life, and I hope that your verdict ensures that Jose experiences lifelong pain that is only a small glimpse of the pain we will live with daily since the loss of Laken. No punishment will ever truly account for what Jose has done, but it is my hope that justice will honor Laken's memory and the profound impact she had on all of our lives. Thank you.
Abby, have a minute. This is Abby Haveland. So, Your Honor, Ms. Carrie Howell will be reading the statement for Abby. And this is Abby's statement that she prepared, but will be read by Carrie.
It was 1:49 p.m. on February 22nd of 2024 that I learned Laken was missing. I immediately text her, "Laken, where are you? Why are people saying you're missing?" Just minutes after 2:17 p.m., a campus email came out confirming my worst nightmare. Laken had been found unconscious and not breathing. Laken, the girl I met in middle school and became best friends with our freshman year of high school. The girl I couldn't imagine being far away from when it came time for college, so we both decided to attend the University of Georgia together. The girl who stuck by me and got me through some of my toughest times in life, as well as accompanied me during some of my best. The loss of her is something I will never be able to come to terms with. I will never be able to come to terms with the fact that I was sitting in class just down the road, going about my day, the morning this horrific event was taking place. I will never not think about the last time I saw her, the pink sweatshirt she was wearing, and the last words she ever said to me. I will never not think about all the things I would have said had I known it would be my last time seeing her and talking to her. Myself, everyone up here, and the world has lost such a special person. Laken was intelligent, patient, loyal, driven, and kind. Her pureness and love for the Lord were evident and shined through her in a way unlike anyone I have ever met before. She is in a better place, but it is not fair that the rest of us still here on earth have to suffer because of this individual's actions. Because of this individual, some of my happiest days, such as the day I get married and have kids, will be forever accompanied by a feeling of grief, a sadness that Laken will not be there with me to experience them. Because of this individual, I have so many fun memories, but no one here to share them with. Because of this individual, I will be searching for the rest of my life for a friendship like the one I shared with Laken, but I know I will never find one because ours was simply unreplicable. I am here today to support Laken. I hope to provide only a fraction of the support she continuously gave me during her time here on earth. I miss her desperately and long for the day I get to see her again. Since February 22nd of 2024, I will forever be changed.
Sophia Plum. Palomino. Palomino. Palomino.
afternoon. February 22nd, 2022 changed my life forever. Not being in Athens that day will forever haunt me. Finding out through an email will forever haunt me. And seeing this posted all over social media will forever haunt me. Laken Riley was my best friend, the person I told everything to, and the person I trusted with anything. The pain of the last 9 months has been indescribable. If you would have asked me a year ago where I thought I'd be and what I would do in 2024, I'd tell you I'd be finishing up my second to last semester of college with Laken as my roommate as she finishes nursing school. I'd tell you we spent St. Patrick's Day together in Savannah, and I'd tell you we went on that trip we planned to New York. I'd tell you she finally got me into running, and she would train me for the Av half this year. I'd tell you many things, and many of our plans, but instead I get to tell you how different my year was. I get to tell you that I can't do anything by myself anymore, even in broad daylight. I get to tell you that a town I used to love being in just fills me with dread. That everywhere I go just reminds me of places we used to hang out and go on walks to. I tell you that I can't go past our old house and haven't been able to return to the IM field since. I tell you the weight of emptiness I feel when I still go to text her sometimes. This is now something I have to live with for the rest of my life, knowing her life was taken too soon and things I was looking forward to will never happen. Being at each other's weddings, graduating together, and seeing each other's start our careers. This wasn't just a life that was taken, it was a future stolen. It's difficult living with knowing that nothing and nobody will ever fill the hole that's been left in our absence. I will never get to experience her famous belly laugh again, her comforting presence, or her cheering me on as we go through life. So many what-ifs play in my head over and over. If just one more thing maybe would have changed her path that day. But instead, my reality is that she is not here. And that because of what this animal did, we have sat here all week hearing every fraction of evidence and reliving the worst days of our life on repeat. I know nothing will bring her back, even though I so badly wish it would. But justice would bring comfort to us all. No one who can take away such a light and sweet soul deserves to walk free ever again. The death of my best friend has changed my life forever.
Carrie Howell.
Hi, Your Honor. I've started this over and over and over. Feeling paralyzed in my thoughts. With overwhelming emotions, not knowing which direction to go, because there's so much that can be said today. Everyone has spoken so beautifully over her, and I had the privilege of getting to speak about her at her celebration of life and getting to talk about all of the beautiful and wonderful things about her. My name is Carrie Howell, and my husband Matt and I have had the blessing of calling Laken and Lauren's parents, John and Allison Phillips, our best friends. John and Matt met in college, where they were roommates and fraternity brothers, and they formed a bond as friends that grew into a true brotherhood. This brotherhood between them extended to connect our families together in the same exact way. It is a friendship that runs deep and loves big. Our families and children have grown up together and had many adventures and vacations together over the last 20 plus years. We have had the privilege and joy of watching Laken and Lauren grow up. 272 days ago, on the morning of February 22nd, 2024, our lives were forever changed in a way none of us could have ever imagined. The moment I got the call from my husband that Laken had not returned home from her morning run, that no one could get her on the phone, and she was missing, I knew in my heart something horrific had happened to her. I had the worst feeling that she was no longer with us, but I prayed and prayed and prayed as I frantically got ready to make the drive to Athens to be with my friends. I was begging the Lord for her to still be alive, and as terrible as this would be, that she had just been kidnapped and would be found physically unharmed and alive, or that she would be able to escape to safety, and praying she wasn't being trafficked. I was literally praying for her to not be kidnapped. Like, that sounds so crazy. But that just at the time seemed better than the alternative. I've never prayed for anyone to be kidnapped. I get the calls on my phone, and in fact, I pray for those people to be found and unharmed. Can you imagine your pleading prayers with the Lord being for someone you adore and love to just be kidnapped? That option gave me hope in that moment that she would be brought back to her family alive. I was desperate for my friends. This nightmare spiraled out of control when I received another call from my husband while he was on the road, or while I was on the road to Athens. John had called my husband, and he said to my husband, "She's with Jesus, brother." That will never leave my memory. As my oldest daughter and I sat in traffic on our way to Athens, time seemed to have stopped in that moment. Yet, as we are here 272 days later, time has continued. It has continued in ebbs and flows of every emotion you can experience. Time has stood still in utter disbelief that this precious human is gone, while day-to-day life continues on. This was an act of pure evil at the hands of Jose Ibarra. He willfully chose to kill an innocent young woman on the morning of February 22nd, with Laken Riley being the young woman he would succeed in torturing in the most excruciating and brutal way, while she fought not only for her life, but for her dignity. He must have believed that she was there for his taking, that he was entitled to whatever sick, perverted urges and desires he had that morning. Not one person on this planet has even one right to take what they want from a person simply because they want it. Yet Jose did that. Because of his evil actions, we are all being forced to learn how to navigate life with the stark, harsh reality of Laken no longer being here. Her amazing friends have been robbed of the beautiful gift of lifelong friendships and doing life together with their future husbands and children, the way my family and the Phillips family have been blessed to do all of these years. Her grandparents and aunts and uncles and cousins feel the absence of her presence constantly and have been robbed of the continued blessing of her being a bright light in their family. My family and I have journeyed alongside our dear friends as they attempt to navigate and learn how to live a new normal without their oldest daughter. I've gotten to know my best friend's face in a new way, a way I would give back if I could make returns on the most devastating circumstances life can hold. I look at her and I know when a situation is too much. I know when a comment is too much. I know when to be silent and when she needs encouragement. This year is showing on all of our faces, like the harshness of cold winter days, that there seems to be no end in sight. But we will keep fighting because we refuse to allow Jose Ibarra to take anything else from us, and we serve a good and mighty God. We've already been forced to journey through our annual family vacation without her. Family get-togethers, fun events. And the absence of her presence is so deafening. I mean, sure, we still laugh and we're still living. We're still here. So we have to keep living, and we're going to honor her with everything that we have. And we're just going to keep trusting in the Lord to help our dear friends and sweet Lauren with all of the things that they're now not going to experience with their daughter. No parent should have to say goodbye to their daughter in this manner. The loss of a child is devastating no matter what the circumstances are. But when it's something like this where evil intentionally goes out to harm somebody, there's no words for it. And so today I stand before you with her friends and family, and we ask you, Your Honor, to bring earthly justice for our precious Laken and for all of us who love her so very much. She was truly one of the most precious people that I've ever had the honor of knowing. She exhibited the fruit of the Spirit in the Bible because she truly lived her life for Jesus, as you got to hear John read in her journal entry. That was her. That was a private entry, not for anyone else. And you got to see the type of person that she truly is in her heart. Pure and lovely, and her laugh that everyone has talked about, literally one of all of our favorite things about her. And we never get to hear it again because of him. So we ask, Your Honor, for you to consider in your sentencing for him to not be able to ever be out of prison and for him to spend all of his days there without any possibility of getting out. Thank you.
Tell me your name.
It is Carrie Howell.
Carrie?
Yes, sir.
And Your Honor, that at this time completes the statements for victim impact evidence from Laken's family and friends. The state would also have a few more items to present for victim impact, and then I'll address the indictment with the court. And one of the things I wanted to share with the court is that a lot of times when we hear victim impact evidence, it is very much so the way that we hear it here in court. Hold on, I'm going to pause this for. But what we have in this case is something that I ran across in my review of the evidence in this case, which is really 1 minute of when or where this court will be able to get the true impact of what the murder of Laken Riley did to her family and the impact of his actions on her family. Because what the investigators did in this case is, as you know, they were all wearing body cam videos, and there's hundreds of hours of it in here. And there is one moment where, and I'm just going to play 1 minute of it, just 1 minute of the horror that this family has gone through in the last 9 months and what they're going to continue to go through for the rest of their lives. And it is the moment that they learned that their daughter was dead. And in this video clip that I'm showing, which I've marked as states 333, at the top right corner, it's at 1950, you'll see a black truck.
Okay, let's step up here. Come on, let's go. Come on, here, all right? Jose.
That's what they endured. And that's how it was on that day when they came here to look for their daughter. And what it took away, you heard from her friends and family, and some of the things that you even heard in the trial. You got a little peek, just a little peek, about the personality of Laken Riley. For example, in Lily's 911 call, one of the things she says is, Laken never misses class. Never misses class. That's the kind of person she was. And in our review of all the evidence in this case, some of the things we had to look at were the social media presence of everyone, and there was a lot of digital evidence in this case. And the review of the digital evidence, I want to share with you just some of it, which has been marked State's Exhibit 336, is that Laken was a very joyful and quite silly, playful person. And a lot of that is viewed in her social media. And the Ring doorbell. Running. Same race. And these are just little snippets that we saw in the investigation that we thought would be important to share with the court, that shows not only the type of person that she was, that you just heard from her friends and family, but the true impact that her murder had on her parents. But more than that, one of the things that the court is permitted to consider in victim impact testimony is the impact that her death has on this community. And in that regard, the investigative team has spent a great deal of time out there at the crime scene, Lake Herrick, all of those trails, and looking for things, measuring things, just going about the daily jobs of homicide investigators and homicide prosecutors. And one thing that we noticed that's still there is State's 335. It's a mural, a memorial to Laken Riley that is still up there to this day, that shows the impact of her death on this community. And that is something that Your Honor is permitted to consider in deciding what would be an appropriate sentence in this case. And everyone is correct, and I'm sure we'll hear it. You know, whatever you do, Judge, you can't bring her back, and it's horrible. But what you can do is give comfort with your sentence. And what you can do and what you are permitted to do, and what I urge this court to do, and what the law permits this court to do, is to exercise your discretion and your judgment in a way that brings comfort to this community, and in a way that a sentence which appropriately reflects the harm that was done in this case. And a sentence of life without the possibility of parole would bring comfort to this community. And no matter what your sentence is today, and it will be litigated from here to 40 years from now, there is at least one person in this courtroom who will inherit it, and that is Lauren Phillips. That is Laken's younger sister. And she should never, first of all, she's growing up without her sister. She's going to have to deal with elderly parents alone. Her children won't have an aunt. She is an only child. And she should not have to worry 30 years from now, 40 years from now, if he comes up for parole, should he might get out. She should never have to worry about that. And your sentence can ensure that she will not have to worry about that. And so in looking at the indictment in this case, Count 1, the offense of malice murder, which this defendant has been found guilty of, in this particular case carries a maximum sentence of life imprisonment without the possibility of parole. It carries a minimum sentence of life imprisonment with the possibility of parole. The state is requesting that you sentence this defendant to life imprisonment without the possibility of parole, not only due to the victim impact testimony, but also because if you read the indictment, which you have obviously, and you're familiar with the facts of the case because you've heard the case, there are several statutory aggravators in this case that separates this case from a regular murder case. And yes, there is malice murder, and all malice murder is bad. I'm not saying there's a malice murder that isn't bad. But there are some malice murders which are more aggravated than others, and this is one of them. Kidnapping with bodily injury, which is the felony murder in count 2, which by the way would be vacated as a matter of law, but not the kidnapping itself, which is count 5. But kidnapping with bodily injury is an aggravating statutory factor under our sentencing scheme in the state of Georgia. It makes malice murder worse than regular murder. And for that reason alone, you should sentence this defendant to life without the possibility of parole. Aggravated battery, which is also in this indictment and which is also the facts and it's also something he's been convicted of, is also a statutory aggravator under our statutory scheme, which makes this murder different and worse than a regular malice murder. So there are aggravating circumstances, which you have already heard, which I will not repeat to you, but that are not only recognized by the facts, but are recognized by our statutory sentencing scheme. So going down the rest of the indictment, felony murder count 2 is vacated as a matter of law. Felony murder count 3 would be vacated as a matter of law. Felony murder count 4 would be vacated as a matter of law. On count 5, kidnapping with bodily injury, the state is asking you to sentence this defendant to a sentence of life imprisonment with the possibility of parole, which is the maximum for that count. And we are going to ask that you run that consecutive to count 1, a sentence of life imprisonment without the possibility of parole for the malice murder. Count 6 is aggravated assault with intent to rape. It does not merge. In fact, it is a separate crime under these circumstances. The penalty for that is 1 to 20 years in prison. The state would be asking you to sentence this defendant to 20 years to serve in prison. Count 7 of the indictment, the aggravated battery, would merge as a matter of law into count 1, so we would not request a sentence on that count. Count 8, obstruction or hindering a person making an emergency telephone call, is a misdemeanor. The maximum penalty for that is 12 months to serve in a county jail. We ask that you sentence him to that and run it consecutive to any other sentence that you impose in this case. Count 9, tampering with evidence, the way that it is actually alleged in the indictment and factually it is a misdemeanor. So the maximum for that is 12 months to serve in a county jail. We ask that you sentence him to that and run it consecutive to any other sentence that you impose in this case. And finally, count 10 of the indictment, peeping Tom, is a felony which carries a penalty between 1 to 5 years in prison. We ask that you sentence him to 5 years to serve in prison to run consecutive to count 1. So to sum it up, the sentence would be on count 1, life imprisonment without the possibility of parole. Count 5, life imprisonment with the possibility of parole to run consecutive to count 1. Count 6, 20 years to serve to run consecutive. Count 7 will merge. Count 8, 12 months to serve to run consecutive. Count 9, 12 months to serve to run consecutive. And count 10, 5 years to serve to run consecutive. And that is the sentence that the state is requesting.
Mr. Donnelly.
Yes, sir. Thank you. So obviously the court is aware that on count 1, there's really only 2 options before the court. It's an automatic life sentence. The only option is whether the court can indicate that it should be without the possibility of future parole. We're asking the court to not impose that. the life without parole. Getting a life sentence is automatic. There's certainly no guarantee of parole, and would be uncertain, and it would be many decades in the future. And we do not oppose the state's recommendation that the life sentence, which is also mandatory on count 5, be made consecutive. We certainly, just to state the obvious, trust that the court will not consider for sentencing purposes the fact that Mr. Ibarra had a trial. The defense has made every attempt, made every effort to do its job and to pursue this process in a way to respect both the process itself and also to not cause any disrespect toward the feelings of Ms. Riley's loved ones. And if anything like that has happened, it certainly was not intended. And the defense is not immune to the sensitivity of this case. Again, to not only her loved ones, but to the greater community. The state's request is not unexpected to us. We anticipated that, and it's certainly understandable. And there is, though, a divide there. The state, while it is understandable the request that they make, the court, there's some separation given here in this process, and the court will be the one to impose it. So our request that you give consecutive life sentences on counts 1 and count 5. We have no position on the remaining counts. We'll send a message that to whatever future custodian of Mr. Ibarra as to the gravity of this crime and the gravity of this situation. That the court has expressed an intention for, it's obviously a legal fiction that he would serve 2 life sentences behind bars, but the law allows that, and it does, it sends that message to the future custodians as to the gravity. But the withholding of the life without parole aspect of count 1 would at least give Mr. Ibarra the sliver of incentive to reflect and conduct himself with some recognition of that reflection. The state agency and the staff of that agency, who will be tasked with supervising his custody, will have the opportunity to monitor him closely for, again, many years, many decades into the future. And it's impossible to know the future, obviously. But by imposing life sentences without removing the future custodians to the ability to do their job is our request at this time. And we also would point out that given his status with, there is an immigration hold, that were he ever in the future to be released, it would only to be deported. And that's all I have. We leave it in the discretion of the court. Thank you.
Before I announce the sentence, let me, I just have a couple of thoughts. One is, oftentimes people use the term closure at an event like this, and I acknowledge that there's no such thing as closure. There will not be closure. This is just another stage or event in this tragedy, and that's the way I view that. People mean well by saying that, but it's. I've heard it explained that when you have something like this that impacts one or many, you even have to make a conscious effort to breathe at sometimes, and that just comes on you at any particular, you just don't know what's going to bring it on you. And you realize that you do make it through the day, but you don't know how you did it. But I also, and this goes back to what Carrie Howell was saying, that as many times as you reflect on the loss, at some point you start smiling about the memories, and I'm hopeful that at some point that takes over to a certain extent. But there's very little, including the sentence of Mr. Ibarra, that's going to help much, and I acknowledge that. With that, Mr. Ibarra, if you will please stand. Count 1, malice murder. I sentence you to life without the possibility of parole. Count 2 will be vacated as a matter of operation of law. Count 3, vacated by operation of law. Count 4, vacated by operation of law. Count 5, life in prison consecutive to count 1. Count 6, 20 years to serve consecutive to count 5. Count 7 will merge with count 1. Count 8, 12 months consecutive to count 6. Strike that. 12 months, but I don't want it to 6. It's just going to be consecutive. Count 9, 12 months consecutive. Count 10, 5 years consecutive to count 6. So that would mean the misdemeanors would come after the felonies. That will be the sentence. Mr. Ibarra, I will advise you that you have 30 days from today to seek any post-judgment relief in the form of a motion for a new trial or appealing this case directly. If you make a motion for a new trial and that is denied, you have 30 days from that date to file your first appeal, first level of appeal. Court will appoint a lawyer to represent you if you cannot afford one. I'll also advise you that you have 4 years from the date that your conviction becomes final in order to file a habeas corpus petition. Mr. Donnelly, can you tell me, are you all going to be involved in the next stage?
That remains to be seen, but my understanding is that we will remain on at the court's appointment until, unless relieved by conflict counsel.
All right, and you'll make those
We will
arrangements.
communicate that with Mr. Ibarra and with the court.
Okay. All right. Anything else, Ms. Ross?
No, Your Honor.
Okay. It's going to take a little. Yeah. Can we take the? Okay, that'll be fine. Can do that.
Everybody remain seated, please.
All right. That will conclude the proceedings. Can I ask you something, Dan?
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, unite.